but he was second highest topper in the written. And
Problem is the 40 minimum marks.
no, but my lord, I'll address this cutting, overwriting, etc. Your lordship may fix a date next week, my lord.
That's good.
All. Now, my lord, this relates to selection to the post of Home Guards in Jharkhand. Now, my problem is that there is a general allegation that there was corruption, but nobody has gone into it. Your lordship might recollect, my lord Justice, the Chief Justice, that this is that case where judgment by the single judge was reserved in April 23. Then we filed the writ petition here after 2 years. And in May, your lordship first ordered that it should be decided. It did not get decided. Your lordship passed a preemptory order on 23rd May 25, saying decide within 8 weeks. Then the judgment comes on 15th of July. Please see that judgment, my lord. My lord, actually, the point is that there is no sustainable allegation. If your lordship will kindly see.
Videography, Mr. Patwalia, there is no videography record of the physical of the
My lord,
candidate.
so
The absence of mandatory contemporaneous documents for verification of the result, it is a prudent course to cancel the exam.
So, my lord, so far as videography.
If there is a prudent course, no right accruing to a candidate, we do not see any reason to interfere.
My lord, the point is that just see the 3 documents which are relied upon. In those 3 documents, the only thing is videography is missing.
Correct.
Videography of the selection process.
Correct.
There is no allegation on the selection process.
Does not matter.
The allegation
Does
is.
not matter if the substratum for verification of the correctness of a selection process is intentionally corrupted. We have reasons to believe that it is not a fair.
Actually, the point is, this is a general impression. Nobody has gone into it at all. Nobody has gone into it, whether there is a single allegation.
Not in the business of convicting anyone or apportioning blame. We are on the fairness of cancellation. Yet we cannot say it is an imprudent, hasty, motivated, or malicious act to exclude you.
The point is,
that is
the point is that general allegation is made that in the newspaper it came, there is corruption.
We won't have
Where is that single proof, single incident?
Mr. Patwalia, we are neither impressed by general impression in newspaper, nor the FIR registered with regard to bribe. But we are definitely worried that if the videography of the physical examination is absent and intentionally not kept, preserved by the person concerned against whom steps have been taken, the authorities have rightly cancelled it as a prudent measure.
So, my lord,
How can
so on that, the submission is there was a dual allegation made in 2020 recommendation. Lodge FIR, take departmental action.
2020 is the red herring in this case. 2020 relates to a bribe for a second list.
Correct.
So please don't take us to 2020. That would be your most attractive argument.
But there is
now you come to the argument where your selection becomes doubtful.
Yes.
The
now
corresponding videography to verify the result has been intentionally removed.
My lord, those are letters of 2021 actually.
Correct.
These are, my lord, Adivasi girls. They got selected as Home Guards.
Completely, perhaps your client is the most deserving client, but there are deaths in crossfire. We can't help it. They will again be selective. We can't.
Actually, if your lordship will kindly see those 2 letters, make 2 recommendations. Neither an FIR lodged nor departmental action taken. Only the selection is annulled.
The point is that in such a situation, benefit of doubt should go to whom?
But it should. My submission is, if the selection process is tainted, I am the last person to say it should be allowed to go through. But you just can't make a general allegation without a single instance.
There are 2 fact pending inquiries, kind of preliminary inquiries.
Actually, if your lordship will just see.
Based upon that, against the commanded to
আচ্ছা, তার মানে ক্ষেত মজুরদেরও সরকার এখন থেকে টাকা দেবে?
হ্যাঁ, দিদি দেওয়া ভূমিহীন সহায় উদ্যোগের মাধ্যমে আমরা যারা ক্ষেত মজুর নিজেদের জমি জমা নেই, তারা তো প্রতি বছর 4,000 টাকা করে পাচ্ছি।
দিদির 10 প্রতিজ্ঞায় উন্নয়ন হবে আবার বাংলায়।
We won't say even 2 pages. What is of relevance is 2 paragraphs
Correct.
at page 582, 583.
582 para 9 and
Yes.
589 para 12. Those are the only two paras.
Those are the paragraphs.
Para 9 he says
Those
that
are
there
very
are,
difficult paragraphs.
para 9 he says there are general allegations, then law is cited and then he says I uphold. Because my lord, probably after 2 years there is a limit to what a person can
There is a
retain.
division bench chief justice judgment deals with the legal
But
position.
the division bench also does not go into the any allegation. Those letters are reproduced and then he says, actually the problem is, my lord, that because of the time which had gone by. But my submission is, there is not a single allegation, there is not a single instance, not a person who says there is any error. Apart from this, that the videography is missing. I am not to be blamed for the missing
But
videography.
this is where, Mr. Patwalia, you are changing the reference of testing the decision. It's not whether you are involved in the corrupting of the entire process.
Correct.
But it is a consequence of a corruption from which, and as the division bench rightly says, we cannot rescue the innocent from the guilty. So it has to be a broad-based cancellation.
My only point is that this is just a general vague allegation. There is not a single instance. Nobody has gone into a single instance.
पैसा खाते हैं 10 के साथ
Then
Well, actually, the division,
see
just see para 22.
process. You will get a chance, maybe that you succeed, you see no ground for confusion.
Grateful.
May I please, my lords? Because item 34 is a miscellaneous application moved by the registry, my lord. What had happened?
Deposit was
The judgment of my lord said appellants. So the persons who had deposited this money, my lord, we had moved the
Advaita and
letter.
credit,
I'm sorry, my lord.
Advaita and credit,
Advaita and Trade Solutions, my lord. Those are the ones who had deposited.
and credit on behalf of them.
Because the office report records that they were the ones who had deposited. We are seeking a refund for them only. There's only one request that I wanted to make, my lord. Some time bound or date may be given for this reason. Every day, 7 lakhs of interest we are paying, my lord. And almost 2.5 crores we have already spent as interest from the date of judgment till today, my lord. Some last date or some timeline direction may be given, my lord. They may release. Everything is over from our side. Everything is over from their side. Just a formal direction is required.
Let's see, in view of the office report, our judgment repeat. February 18, 26 is verified. The extent that the amount set is 25 crore and 100 crore will be released in the following manner. One I, rupees 25 crores having been deposited by Advaita Fine West Private Limited, bracket on behalf of sole appellant. The said amount shall be released in Advaita Fine West Private Limited. Two I, the amount of the 100 crore was deposited by Credit Solutions India Trust on behalf of the sole appellant by way of demand draft number 295423. And hence the said amount is also directly to be released in favor of Credit Solutions India Trust. The registry shall do the needful within 2 weeks.
Grateful, my lord. Well, let's just say along with interest accrued because it was kept on a fixed deposit receipt, my lord.
Along with the interest accrued thereupon within 2 weeks.
So grateful, my lords. Deeply grateful.
Well, the NCLAT itself says these are issues to be decided. I'll decide it on the 10th, Mullahs, but in the meantime, you implement the plan. Well, I don't understand. Mullahs, we are not going to take a date. Let this be decided, Mullahs, and why allow the company to be delisted, Mullahs? And he says, one, it's delisted, it can be listed
It
again.
was of upfront amount.
Yes?
The issue was probably of the upfront amount.
But Mullahs, kindly see the substantive part. Kindly turn to Mullahs page In the volume, Malaz, volume 2, page 314, straight away, Malaz. I'll just show you one data, Malaz. First of all, I get a letter that I am the highest. I'm sorry. Malaz, first 306, kindly see, Malaz, the letter that I received from the resolution professional.
Page.
306, volume 2.
Hmm.
He says, please note that after the challenge mechanism, please note that the highest value as per identified criteria at the closure of the challenge is rupees so and so on NPP basis. So we are highest in substantive terms and on NPP basis. Then Muller's comes 314. Now, if this plan is implemented, let's see what the creditors get. 314 is the final tally. Taking everything into account, I am on the last Muller's column, 17,000 crores.
Where are you reading?
Muller's page 314.
314.
Yes. This is now the final tally.
Hmm.
Muller's, I am in the last column, 17,926 crores. He is getting this for 14,535 crores.
No. In the
So under my bid,
page 314, there are two tables, on the top and then.
the top table, Muller's, the top table, that's the final tally. Muller's, I am at the end, 17,926. Your Lordship has that number?
17,926.21.
Yes, that's my number, Muller's. That's the amount that I was to pay to the financial creditors. They are paying, they get JP, they are paying for 14,535. I'm talking, Muller's, on the final analysis, the creditors will get more. 3,500 crores more.
So then you are saying for by 5 years.
No, the
Other-
net present.
Yes.
Muller's, kindly see, net present value and total amount, I'm still the highest. Yes.
So that had weighed with the COC.
But Muller's, that's the point, Muller's. The COC is willing to give JP for 3,000 crores less.
Problem
Take
is-
less money.
Muller's, that's the
different
substantive
time.
issue. Muller's,
Problem is the commercial wisdom and our expertise.
Muller's,
The, whatever we as laymen could understand, that your offer of 17,926, we will take it almost 18.
100 रुपया है सर ऐसा ये 100 रुपया देगा
This is what is being considered.
that's what is being considered, Muller's.
Going to be considered because it's been an addendum.
Muller's, that is exactly what is being considered.
They rejected this, they rejected by saying that it came by way of an addendum.
That's right.
Objected to the full balancing of interest. SRS paying everything to, they are taking five. SRS paying everything to, they are taking five. And the division gives a lot of. SRA got 89 and division 76. So the Western District also they were H sweet. 70 and 50. Like 89 and 76.
I don't want any relief, Muller's. All I want is the matter is being heard.
Mr. Sibal, we have two difficulties. One is that right now it is only an interlocutory interim.
Correct. I don't want your lordship to interfere, Muller's. I want the matter to be heard on the 10th. In the meantime, nothing should be done, Muller's. No. To unscramble the deal will be impossible, Muller's. They want to buy the Formula One, Muller's. Formula One is also with JP. They'll buy that. They are going to do several other things. So all that I want is on the 10th it be heard. I'm not taking an adjournment. They may not take an adjournment.
Suppose it is implemented without prejudice to your right.
The creditors will go away, Muller's. All the money has been paid. It becomes impossible.
15,000 creditors.
15,000 creditors will be paid. Where will we get it back? Operational creditors will be paid.
I'm appearing for COC. I have a suggestion. Please have a look. Please have a look. I am appearing for the COC and the difference
The troublemaker.
No, I'm not the troublemaker, the distinction,
Oh,
no,
the-
of course, my lord, the issue is pending before NCLAT, so I may not go into the merits. But for us, practically the difference is 500 crores. And there are several metrics on which, my lord, the voting
We know
takes
that, that's on merit.
There is an application of, yes, that's on merits.
Yes.
Biggest issue was only
Please come to page 3, para 7. Lord, this implementation takes 50 days. Nothing can happen within 3 days. Please have a look, my lord, at para 7. This is what, my lord, my learned friend wants your lordships to interfere with.
Mr. Solicitor, that is exactly what we were proposed to you or to the successful resolution professional entity that since the matter is before NCLAT, the resolution plan, the successful resolution plan being accepted, let not substantial policy decision be taken without the leave of NCLAT.
Lord, may I suggest? May I show, my lord, one paragraph? I think that takes care of your lordship's
Do you
concern.
understand that it cannot be like at the interim stage?
No, we don't want that.
Then we will
don't
have to
want that.
necessarily satisfy your lordships on merits. Because the only argument which prima
That is what
facie.
we are saying, there are two
We
things.
will not,
One is whether the addendum that they put in was in breach of the process note
It
and
was.
regulation. No, that will be a thing which is to be debated upon.
Lord, would your lordship
Secondly is how far Binani NCLAT decision is distinguishable in the facts of this case.
Lord, only one thing. Lord. Kindly have a look
These are
at, my
issues
lord, one
which
para,
are decided
one page.
in
Of
the
course, it's
meantime,
before.
If it is not, it will be a time-bound NCLAT hearing. In that time frame, do not take, at least the success will be.
The monitoring committee may be in
Only-
place, that's all. We don't want anything more. my lord. Monitoring committee may be in place.
That means he wants stay. Lord, I'll explain the scheme. It was a
Monitoring
very,
committee
very-
may be in place, my lord. They should not be disbanded. That's all. It's already there.
Monitoring committee cannot be disbanded, my lord.
No, say that, then that's all we want.
Give me the chart. My lord, there is a chart. My lord, it's not on record.
Because
it's on
they should not
record of-
delist, my lord.
Only
What
a
happens
minute,
is,
sir, only a minute.
it will be, one second, it's a private company. Ultimately, it's a private company after this. It's a listed company. Otherwise, it'll be delisted. Then, my lord, to list it back, all difficulties will arise.
My lord, now kindly up. Lord, what has persuaded your lordships, my lord, without, my lord, taking your lordships through the facts, that my plan is better, I'm giving more. My lord, initially, my lord, the plan of the SRA and the number of days in which the upfront payment was to be made, my lord, was better. Now, my lord, without going into the question right now for the purpose of interim order, whether addendum or subsequently it could have been, after knowing their bid, it could have been done, etc., etc. The difference is 500 crores.
Even then.
It's not, my lord, as if, my lord, it is a difference of more than double. My lord, that is what the impression which is, my lord, created.
No,
My lord, therefore, page 3, my lord, for my satisfaction, have a look. Has, my lord, the tribunal in an interim order, my lord, taken, my lord, care of that or not? My lord, para 6 and 7. Para 6, 7 and 8.
That's
Please
on
have a look. My lord.
merit.
Kindly have a look. Page 3. The order impugn itself. My lord, when your lordships are dealing with an interim order, when the matter, both sides agree will be heard on 10th.
We have seen.
Both the-
first time we have seen it. Para
Now, kindly allow me to read. Both the parties are also permitted to file, that's ignore note 7. In the meantime, in pursuance of the impugn order, the implementation of resolution plan shall go on. However, that shall abide by the result. Everything can be nullified.
No, that-
Now, please see page 8. Mr. Reddy, my lord, is with me, my lord, in this. Learned counsel for COC submits in the event delisting takes place of the corporate debtor as per the approved resolution plan under the impugn order, and the impugn is set aside by this tribunal, there shall be automatic cancellation of delisting. But this is not going to happen,
Yes, this may not happen.
cannot happen within 50 days.
That is what-
That's how there are stages. What happens is, let us be practical.
Because today what has been rejected by the NCLT is an objection to the decision of the COC to approve the SRS.
No, my lord, that's the problem, my lord.
Approval of the
No,
SRS.
that's the problem, my lord, when
And
we.
now that COC decision has to be approved by the adjudicating authority afresh. That has already been done.
It is approved.
Already done.
Yes.
It is approved,
On the same day, my lord, I'm sorry, let me,
Now, my lord,
one second.
it was, my lord, now on Friday it has to be heard.
Yes, so
Well, stop allowing the appeal in their favor are provided in the.
I
order.
don't want an
RP, I have to say something. I'm
Well,
the
thanks,
RP,
my
but
lord.
I have to say something.
Tenth, we are not going to take a date, let the matter be
No,
heard.
I am also not, we are not going
Mr.
to.
CEO,
Yes.
Mr.
In the
CEO has
meantime, my
spoken.
lord,
One thing your lordship should know for the RP, Manas. I'm the RP.
The matter is now listed on tenth.
Yes.
We will request NCLAT.
Yes,
Hear the matter on.
yes, yes.
We will also request both sides that you will please cooperate with the tribunal.
Yes, yes, yes.
Statement
No,
is recorded.
there also be record, no adjournment will be sought.
Nothing is going to happen as such in couple of days or so, because ultimately it will take time. We are simply saying that if the resolution professional, we are simply, just listening, Mr.
Yeah, I'm sorry,
maybe
sorry.
that it doesn't harm anyone.
I'm sorry, my
If the
apologies.
resolution professional, even during this day, if he wants to take any policy decision, he will seek prior approval of the NCLAT.
That's fine.
Resolution-
That's fine, my lord.
We must assist your lordships correctly. Resolution professionals, now management committee is in place under the act.
So management
Committee will
But the management committee has just invited applications for implementing agencies. Lord, it is
Fine.
more for
Very fine. We are not stopping any of this process. Let them.
Manas, can I just tell lordship?
difficulties, Lord, what is major, what is not major.
Can I just say one thing?
That anyone with some experience of corporate management knows what is major and
No,
what is
Manas,
not
I-
major.
we hear your
In the
lordships.
ordinary course of business, whatever you do is not major. But if you are going to make a substantial acquisition, a merger, etc., etc.
Settlement.
will be
Okay, Manas, allow me to give you.
not contemplated. Within
Fair
50
enough.
days, it will not.
Manas, we will do whatever your lordship will think appropriate. Just give me 2 minutes on some facet your lordship doesn't know. There is no problem, Manas, if your lordship thinks that is necessary. My learned friend says his entire case is that he's a better offer. Right, Manas? Just note these 2 things and I will not say anything more. Both of these sides, that is Manas, Mr. Sibbal's side and Mr. Rothgi's side, were called together on 7th November. On 7th November, it was told to both of them that now voting is about to start. This is your frozen plan. They both go home without a single objection. Obviously, somebody leaks somebody to something to somebody.
So we,
No, give me a minute, Manas, give me a minute.
our difficulty that this will amount to traveling us into merits of the case.
Not only merits. No. These are admitted facts. No, this is something very
He
serious.
will,
7th, they go home. The voting starts from Manas 10th to 18th. It's an 8-day voting. After they go home on 8th, Mr. Sibbal's client makes this so-called better offer after the thing is frozen.
but,
Manas, your lordship has done enough tender matter.
Well,
Everybody can make
may I
better.
then tell your lordships,
Everybody can make. I can make a superb offer.
he stopped participating in the tender after the second vote, my lord.
We have our own difficulty. We will not say anything.
And
Yes,
secondly,
exactly.
Manas, CIRP urgency and my lord's
Well,
judgment
he
authorized.
doesn't tell your lordships
In February 26 called.
that he does not participate in the challenge process completely, my lord.
Your
He
lordship
stops on the
judgment-
second round.
Your lordship judgment, Justice
And Manoj-
Bachi authored it
Yeah.
about.
Who knows what he has
Minister.
said? So all this will be argued.
Only a minute, Mr. Sibal.
And he's still not the highest bidder. Even
Violating your own
according
rule,
to
Mr.
he's still
Sibal.
not the highest bidder. He says 500 crores more I have, even now.
I saw that.
Anyway, I don't want to argue the
We are
merits.
not going into the merits at
Exactly,
all.
but my learned friend has always something to say.
Easy to make a better offer after a leakage.
Yes, he'll always have something to say.
Keeping our comments reserved for the next round.
Well, it's a 2024 process.
That
The
next one will
CIRP should get over-
be 2 against
CIRP
5.
should
my
Get
lord.
over quickly.
There is one more issue.
2 against 5.
There is no substantive challenge.
Yes, yes.
By Mr. Sibbal's client to my plan.
Yes, there
His
is.
challenge is why his addendum was not taken.
No,
etc.,
no. The process. It is a challenge to the process. Why do you say that?
They will amend their appeal. We'll add this down.
Therefore, my lord, what your lordships heard was a part of the submissions, not full picture is before you.
Because I haven't paced the
My
full,
lord, it
paced the
would
full.
really amount to modifying or, my lord, changing the interim order, your lordships may not do that. That's the only thing we did.
I mean, one fact, never has a communication gone from the RP
Again.
saying
Merits,
that
then
he's
it's
best
not
or
on
he's
merits.
best. Never.
He always says that.
Council on behalf of the applicant, as well as so-and-so, learned senior counsel, as well as Sri Tushar Mehta, learned Solicitor of India, representing the COC, Committee of Creditors, as well as Sri so-and-so on behalf of risk number 3. In view of the fact that company appeal in bracket 80, again in bracket insolvency, number 552 and 553 of 2026 are now listed for final hearing before the National Company Law Appellate Tribunal on 10th April 2026, we see no reason to interfere with the impugned order passed by the inclat. So, however, having regard to the nature of issue and its consequential implications, we request
आग की आंच पे उलट पुलट नाचता, गुलट सुलट ठुमकता, इस मटकते चिकन पे जब गिरेगा बटर तो हो जाएगा ये चटर पटर। और इसकी सौंधी खुशबू से बॉस को एहसास होगा कि ऑफिस के बाहर भी मिलते रहना चाहिए। तो मिलते रहो, क्योंकि मिलने की भूख अच्छी भूख है।
for the timely adjudication of the appeal. To assist the Honorable Tribunal for the final hearing on the date fixed. Next paragraph. Since the appeal is likely to be decided very soon, there may not be any, there is soon, and the interest of the appellant has been adequately protected by the inclat through para 7 of the impugned order, there is no necessity to issue any interim direction.
7 and 8. Huh? 7 and 8.
7 and the impugned order.
Yeah, 7, 8 and 9.
Sorry, 6, 7 and 8. I thought that.
So,
I stand corrected. Last two.
There seems to be no legal necessity to issue any other direction except to observe that the managing committee, if decides to take any major policy decision, monitoring committee, if decides to take any major policy decision outside the resolution.
Has to be outside, that's the law.
One second. It
Even if you get full
the
stay,
plan,
that's the
Manoj,
only
how can you
stay
say
you
outside the plan? How can it be outside, Manoj?
It may seek leave of the inclat.
Your Lordship, I couldn't hear what my Lord has said. Your Lordship has said,
In case of any major policy decision, the monitoring committee may seek leave of the.
deeply obliged, deeply obliged, that's all, deeply obliged.
Please, Your Lordship.
Yeah.
Yes.
Volume 2, actually, although the paper book is quite heavy, the issue is not very complicated. Lordships, just see page 274 for a minute. We can simplify the issue.
The entire issue was restricted at the High Court level with regard to the
Demarcation.
the pathway.
No, my lords, Lordships, therefore, I just want to point out 274, what the controversy is, my lords. If your lordship sees page 274 for a minute, it's actually a narrow controversy, not a very complicated one. If your lordship sees page 274, this is a map submitted by the developer. And I want to make some things clear, my lords. What is enclosed in the red area is actually the slum area. And we are not opposing the redevelopment of that slum at all. We made that very clear to the High Court, and we are reiterating, nobody is coming in the way of redeveloping. It's wrong application, my lords, of a development regulation. Under the regulation that was to be applied, if your lordship sees page 274.
No, what do you want to show from page 274?
Sorry, my lords.
What do you want to show us page 274?
It's a map, my lords. It's a map.
Problem.
Volume 2. The red area, my lords, we have no objection to the redevelopment of that area. Well, it's no, my lords, it's not a road that's being constructed. What is happening is the slum area has to be redeveloped.
Dr. Mulvidhar, please come to page 275. The satellite picture
Yes,
is
yes.
better.
Yes.
And what, in all probability, the dispute is that wall.
Correct.
And on the left of the wall is the slum.
Where we are not.
And the pathway between the abutments and the
Yes,
wall
yes.
is the area which is in dispute.
No, that it's not just that, Malaj. If it was only that, again, we may not have had a problem. The difficulty is having demolished the wall, we don't know where this is ending. So we had requested the High Court and the committee was set up only for the demarcation. And that the committee does not do.
All the no, no. What he's saying that the wall.
Please, Malaj. That was really the only issue.
Sir, please, file a review petition before the.
Well, your lordships will also add that line because what happens is then coming back here becomes difficult. Malaj. Let us point this out to the High Court because this was the real controversy. Malaj, we'll go back to the High Court, but your lordships should not prevent us from coming back here in case we don't succeed. That's the only apprehension.
Samapping is the review order, but not the original order. Not the original order. Original
Well,
order.
if the review is dismissed in one line, which it can, then we are stuck, Malaj. This is the difficulty. If it's a detailed order, there's no difficulty, then merger doctrine,
Will not have.
yes, then that's not a problem. And your lordships, other benches, coordinate benches are doing this. When they permit us to file a review, your lordships are permitting us to come back.
Anyway, if anyone appearing for the authority, this demarcation of line, even you can do, there is no need to go to High Court.
Please,
Look at page 38 of the impugned judgment. The High Park committee appointed.
No, that's the problem. Malaj.
Beyond this 12.2 meter road. Just look at the last line on page 38.
Malaj, it does not the only
High Park
controversy.
committee says that under this plan, a 12.2 meter wide development control road is proposed on the eastern side of the slum rehabilitation scheme to serve as a missing link between two existing roads. Once the DC road is developed, both ends, that's ingress and egress, of the previously existing footpath will be connected and the difference in distance will not be significant. Now, Malaj, why should there be any interference when they say that the development
Malaj, there is a
plan road
real,
coming up?
Malaj, what happens in this, they're applying the wrong development regulation. The builder is supposed to surrender back, Malaj, 35%. And that is not happening here. This is the whole difficulty. And there's no controlling what the developer will do, Malaj.
Yeah, they are also unnecessarily, this, I think with this kind of fair and High Court committee is there to monitor it.
No, not for monitoring. Malaj, this committee was only appointed to demarcate. And that the committee did not do. Malaj, let me just be permitted to complete a sentence.
Stream lot is the proposed area as per development
Mr.
plan.
Singh, just let me just complete my sentence.
No, let me just show what your.
No, but I'm being asked something, I have to respond to that. If your lordships keeps both these pages, because they're only separated by one satellite image, 272,
Stream lot.
272 and 274. If your lordship sees
Which is
270,
going from this very land, the demarcated land.
well, it's
We
272
are
and
getting this road.
274, because, well, these are traditional
303.
fishing communities. They have a
the
genuine
development plan.
apprehension because once the wall is demolished,
So there, you see, there is a reference to a special committee in para 34 of the High Court judgment.
we appreciate that much.
Based on that committee, the recommendation.
That's right, that-
is approved by the High Court.
Mr. Diwan was referring to that.
Direct that committee to monitor it. the-
Absolutely, we have no difficulty.
Well, will your lordships permit us to approach the committee then? You lordships permit us to approach the committee then? Very well,
Very right.
very well.
We find from para 35 of the impugned judgment that from para 34 and 35 of the impugned judgment that a special committee comprising of 5 functionaries of the senior functionaries of the state government was constituted, and based upon the recommendations, and its recommendations including 7 point Roman 6 capital inverted comma so and so have been approved by the High Court by the impugned judgment. Next paragraph, the apprehension of the petitioners that in the absence of express demarcation of the wall which is to be dismantled,
Wall already dismantled.
the already dismantled wall,
Wall is already dismantled.
That's the whole
wall-
problem, Milord.
dismantled
That was
wall,
the difficulty.
they are likely to be prejudiced. The petitioners are not sure where the 12.20 meter wide road will be constructed. This aspect, in our opinion, can be effectively addressed by a special committee who can monitor the development work.
Your Lordship will have to appoint them to monitor because
They
their
can
role
revi-
is over.
That can be revived, my lord.
Yes.
We have no objection to the same committee doing it.
Your Lordship says.
Which can be taken care by the Chief Executive Officer of the Slum Rehabilitation Authority. Slum Rehabilitation Authority. The petitioners, if the petitioners have any grievance with respect to the demarcation at the spot,
Yes.
they may also approach the Chief Executive Officer of the SRA.
Deeply obliged.
With liberty of formats, especially political.
Black.
Yes, item 37.
Yes, yes, sir.
I'm sorry.
Second of that one.
Yes, now, may I just state the point? After your Lordship's judgment, which is dated 9th of September 25 at page 121, your Lordship had remitted the matter back on one of the issues because there were factual aspects, etc. So the matter went back to the High Court. The High Court allowed further pleadings to be filed. Further pleadings were filed. As far as the employer is concerned, your Lordship may just see that affidavit is very important. They filed an affidavit indicating that, look, this person, because I'll just recall, just to refresh your Lordship's recollection, the court held that having regard to the terms and conditions of the tender, it was not mandatory for the party to have filed its joint venture agreement or its consortium agreement. So that technical disqualification, which had earlier visited the writ petitioner, was set aside. But there was another aspect with regard to this availability of the colliery, etc., which your Lordship said the High Court will now decide. So pleadings were filed, and the employer filed a very detailed affidavit saying that, look, your arrangement under the consortium agreement which you had was to exclusively, no question of scaling back or available capacity, etc., was to exclusively reserve this particular washing facility with regard to the Maharashtra contract. And by not therefore making a disclosure, and in fact by putting a false impression in your certificate, you failed to comply with the minimum requirements. Now just have a look at their affidavit first, and then please just, I'll just state the point. So the MPGCL affidavit begins at page 207. Sorry.
How the High Court has now dealt with that?
Yeah, now the High Court hasn't dealt with that. The High Court has talked about spare capacity, whereas the issue before the court was the first.
We Day is all of you, the few, the dedicated, coming together to change this world. We Day 2011, are you ready to change the world? That energy, that noise you're hearing all around you, that.
Then I'll just take you to the affidavit of the employer. Your Lordship has page 14, para 29.
Is?
14.
Yes.
Your Lordships have paragraph 29. Yes. Now just see, the respondents have placed reliance on clauses 3.12, 3.13 and 8.5 of the joint venture agreement dated 12th December 2019. The said clauses read as under. Each party agrees, undertakes and ensures that the plants, washeries provided by the parties to the LLP for the purposes of the tender shall be in working condition at all times to execute the works of the LLP. Now 3.13, MMMBPL agrees that the plants, this is the writ petitioner, agrees that the plants and washeries provided by MMMBPL shall be kept free at all times, and no other works shall be carried on by MMM-BPL at such plants and washeries assigned specifically for the tender. And 8.5, Triple MBPL and each of the promoters represent and warrant that the plants and washeries provided by MMM-BPL to the LLP for the purposes of the tender shall be kept free at all times to execute the works of the LLP only, and no other work shall be carried out by MMM-BPL at such plants and washeries assigned specifically for the tender. So this particular washery, which your lordships may just note, I'll just give your lordship the name of that particular washery. It's the Gondegaon washery. Yes.
30, please.
30 of this, of the impugned judgment?
Huh.
Yes, 30. Yes, Manoj, next para. Yeah. As per the petitioner, it owns and operates 6 washeries with the aggregate installed capacity of so-and-so at so-and-so. Out of the total installed capacity of the 6 washeries, only 2.1 million metric tons per annum is currently being utilized, leaving a balanced spare capacity across all 6 washeries. This doesn't apply at all. Can I just state the point? As far as this one washery which was made available is, please just note the name, it's the Gondegaon coal washery. Gondegaon facility was exclusively only under the agreement, under that joint venture agreement designated for the Maharashtra project. That we have placed here on record, page 38. Please see page 38. So he makes a false representation, and I'll take you to the affidavit. That page 38 is the joint venture agreement dated 2nd December 2019. So there's no question of spare capacity. The question is, this is exclusive. Now please see what the stand of the employer. Please see.
Competent authority will examine this part only.
So they examined it.
Paragraph 37 of
No.
the impugned judgment.
Sorry, para 37, yes.
They relied on a letter.
Yeah, so I'm coming to.
They say that they are going to release this washery
Yeah.
from the MMTC contract.
So they never got a reply. So I'm coming to that. That's the second point. But just see this. Please,
So if
now,
that
Melbert,
is
please
so,
just see
then
the states,
then
the employers.
Clause
Sorry?
will give the letter referred
Yes.
to in paragraph 37 is
Yes.
acted upon.
Yes.
Then the Gondegaon washery
Yeah.
becomes free for the use of this.
No, so Melbert, now.
1.5
Okay.
MMTB.
So can I just explain this situation? So I'm going to answer the question itself. Could I just please answer the question first? Sorry,
This contract, what is the duration of this contract?
this contract is still ongoing.
No, what is the total duration?
No, my contract is 3 years. The subject contract here of the writ petition is 3 years. The Maharashtra contract is much longer and it is still ongoing. Now, my lords, I'm answering your lordship's question straight away. Now, first, my lords, please see the stand of the employer before the High Court after the remand. Please go directly to page 215. Your Lord, page 216, I'll take you straight to the relevant line, 216. This is the stand post-remand of the employer. Please see the first sentence. The subsequent placement of this document on record prima facie reveal that the petitioner's washeries are committed to another project. Your Lordship has that? Top of page 216, my Lord. I'm just reading the relevant portion.
216.
Yes, they said, the committee said that, look, maybe it was not a mandatory requirement. It was not a mandatory, your lordships have so held, so there's no question. But even though it was not a mandatory requirement, you were obliged to disclose because your, please see 216, the subsequent placement of this document on record prima facie reveals that the petitioner's washeries are committed to another project. Now, my lords, I'm answering your lordship's question. The commitment, sorry.
That is not correct observation.
It is correct, my lords. It is committed.
As per the JVA.
Yeah, so now your lordship is correctly put it to me.
And that is why the High Court refers in paragraph 37
Yes.
to the letter of one of the consortium member
Yes.
saying that we want to shift
Yes.
the
Now see what happened there.
the Gondegaon washery so that it becomes totally committed to this particular tender.
Yes, but then your lordships will just see paragraph 38 and then I'm going to answer this question itself. With regard to the joint venture agreement, the Supreme Court has held that the production of the joint venture agreement was not mandated by the NIT. Thus, the clauses of the joint venture agreement cannot be relied upon by the respondent to contend that the petitioner did not have capacity as per clause 5B of the NIT.
May not be a very,
Sorry.
very correct
No.
way of expressing
Yes,
it.
yes, just-
But we would rather rephrase it to say that the joint venture agreement must be read with other correspondences between
Yes.
the
Now just-
consortium and the other contractee.
Yeah.
And therefore,
Yes, now just see the letter. Now just see what they did.
Mr. Diwan, it was
Yes.
more in the nature of an executory order
Yeah.
passed by the High Court.
No, but here now I'm coming to a second point to answer your
allows
question.
you to
Let me just
open a
indicate,
refund.
no, let me just indicate what has happened here. They have fabricated a paragraph. So now just let me take you to that because I have stated on affidavit. Just go to page 88. Please go to page 88 and 89. And I stated so. And my officer actually went and I filed it on affidavit. Just go to it. This is the letter which your lordships have also referred to. Please see page 88. Your lordship has 14th June 2024. 14 June 2024, page 88. Now they write to Maharashtra State Mining Corporation and they want to bid for this tender. So they say, with respect to the subject cited above, we kindly request your good self to kindly issue below mentioned experience letter for participating in the tender. Your lordship has that? So now to whom it may concern, and they give the format. Your lordship has that? To whom it may concern at page 88. Now what they do is, they insert a paragraph at page 89. Now this is, Manoj, I'm answering Justice Bagchi's question. That it is to apprise you that Messrs. Maha Minerals and Beneficiation Private Limited is proposing to participate in the tender floated by Madhya Pradesh, published in NIT dated so-and-so through a corrigendum coal washery for MMMBPL, and that in the event of the award of the said tender, we shall be shifting ongoing MSMC work, Mahagenco work, under the contract through to our other washeries. Now, this paragraph is not in the original letter. Just please bear with me. This paragraph is inserted because see the next sentence, that this certificate is being issued on a specific respect of the tender participation. Your lordship has that line. Now, Maharashtra issues that certificate as requested on, your lordship will find that at page 93, without that paragraph. So we are actually sent our officer. I have an affidavit of my particular person. Please just see this.
Mr. Diwan, did
Yes.
you bring this to the notice of the High Court that this is a post-referendum?
No, we filed an affidavit. So the High Court has ignored that affidavit. Just see I filed my specific affidavit, which begins at page 218. And I have got an averment at page 221. Please see that averment at 221. I say that respondent number 2 has a bona fide belief and reliably learned that a paragraph which has been mentioned in the letter of 14 June 2024 as produced by the petitioner herein is not part of the letter dated 14 June 2024, which is part of the record on MSMC. The said paragraph is extracted herein below. And this is that paragraph which I read to your lordship. So they inserted this paragraph even on the last hearing before this court. And we made a specific averment because this deponent, who is Mr. Prashant Jainaraman Shukla, he could only say this, that it's a bona fide and reliably learned because he went and visited the office, he saw it. So we say, just a second. He's inserted a paragraph. What else am I doing? 3.10 in the JBA gives the entire thing is contrary. No. Yes. No. So just a minute. Now, what he says in his reply. So this is very serious because this was in the last round before this court.
It was placed before this court.
That was placed. It's footnoted in your lordship's judgment. And just first thing. It says, please issue a certificate in the following format.
What's the reasons why this court had remanded this issue?
Yes.
Considered?
Yes.
Because this was not a part of the pleading, but a
Yes.
part,
Yes.
the submissions made as a part of an.
So one way out is we issue a notice to this particular authority and ask them to produce their file over here in court over here. Your lordship sees it and that's the end of the matter. That's the end of the matter because I made this averment. Now his denial is also delightful. But the High Court ignored both those. The High Court said that, look, you have just filed these affidavits, the hearing is starting, etc., commencing. I am not looking into either affidavit of either side. So his denial, if your lordship likes, I can show that to you. That is, my lords, in an additional document. Sorry.
Yes, Lord, I'm so grateful. Lord, first I want to invite my Lord kind attention to para 132 of the earlier judgment. This very certificate, the finding by this honorable court, page 132, it is nobody's case that the respondent number 1 had doubted the authenticity of the certificate, this very certificate.
Yes, before us there was no.
There was nothing. Now,
Today, if Mr. Kuda, he may not be aware of an exchange of letter and in good faith may have not controverted it.
Lord,
That
let me-
does
let me-
not give
let me place it.
anything to its genuineness.
Well, let me place it in just 1 minute. My Lord, the letter which I wrote to the authority and the response both were placed before this honorable court in the earlier proceedings. Both these letters were here. They did not raise an objection.
Original letter be placed before.
It was placed before this honorable court in the earlier proceeding.
MSM.
Hold on a second.
Yeah.
Now, my Lord, may permit me, what the affidavit which has been now my learned friend is reading, my Lord, may kindly see P13. This letter is drafted on 25th of November 25. And it was a date when there were 10 dates, matter argued, 26th of November, matter was reserved. After they had taken 10 dates, this honorable court had fixed 2 months. They dragged and dragged because they were executing the project. Just a day before the conclusion.
So which letter are you referring to?
Now, my Lord, may kindly see this affidavit annexure P13, which my learned friend says they had taken a plea.
Page.
This is, my Lord, page 217. 217 is the affidavit. My Lord, may I kindly see the date? This is the affidavit. It's a last ditch attempt being made to drag it. That today they get a stay, they drag another 6 months out of 3 years. They have already done.
Very serious allegation.
No, my Lord, the serious allegation only for the sake of a stay. And my Lord, I show their conduct. This affidavit is 25th of November. My Lord, may I kindly see the remand order is 9/9/25. This honorable court says 2 months. They dragged it. Now this affidavit for the first time coming after 10 hearings on 25th of November 25, the High Court did not even take it on record saying, no, we will not entertain all this at this stage. 26 is the judgment reserved. After 4 months, the judgment is being given. But the 2 dates are
Yeah.
But High Court refused to take this affidavit on record because 26th the judgment is reserved.
Doing something, Mr. Diwan.
Lord, he has agreed.
And Lord, what there is one another aspect.
Yeah.
We will permit you to file a review petition before the High Court. We are specifically mentioning para 8 of your affidavit
Okay, very good.
of so and so date.
This affidavit was not taken on record by High Court saying that this is a belated last ditch attempt. Lord, the only
We will mention both the things.
Yes, very well. And he has filed a
Kindly
reply.
permit me one thing. Now they want a stay. They have already executed half of a project. I'm L1. Lord, they have been playing hide and seek. Here it was very difficult to, even for this honorable court, to bring them to the court and deliver a judgment. High Court has taken, my Lord, how many months? The 2 months were given. Now, factually incorrect plea, of course, serious plea, but factually incorrect. Only in an order to say that today we get a stay, after 6 months, maybe it is found to be correct, and they say, all right, that was our impression. Now the affidavit itself says they have an impression, and now they apply RTI. Lord, in the affidavit, Lord, may I kindly see at page 221. What is the date they are applying for RTI to get the certificate? 24th of November 25.
We would have accepted all your arguments, but for the nature of insinuation or allegation.
Lord, then I would say, please don't stay because my
Letter is found to be incorrect or an incorporation, as Mr. Diwan indicates,
Right.
it would be a fraud which will wash away everything in your favor.
Lord, may kindly consider one thing.
We looked at.
Lord, I'm not.
In fact, instead of them, this application should have come from the Maharashtra Pradesh, the power generation.
They, Lord, in fact, what they are saying, Lord, I just want to show 2 things, 2, 3 things, Lord, allow me a minute. 24th of November 25, for the first time, they say they have applied for RTI to MSME with regard to authority of the certificate.
On that issue,
Now, the letter read, now, my lord, let me show that letter which they say is incorporation. My lord, my application to MSMC is annexure P4. I'm sorry, annexure P3. In P3, I am making an averment. This is an application to them. I'm making an averment to say that I will be shifting this Godegao to another tender, and your bid permit me to change the washery. I'm changing it. Now, while issuing that certificate, of course, that my undertaking is not recorded in that certificate, obviously, and they say this certificate is being issued in pursuance to your application. That application has a format of a certificate, but that format, they can delete whatever undertaking I gave to them in their application. That application is with them. So that undertaking need not come in the certificate they are finally issuing me. The only ground.
You cannot, if you admit that the certificate did not contain this undertaking.
No, this certificate, my lord, this undertaking is there in my application to MSME.
We understand.
And when they issue a certificate, they say in reference to your application, we permit you to give a bid.
Now you are inferentially reading that undertaking, but what was relied upon is a certificate where unequivocally this
No, the certificate I'm relying upon is not annexure P3. The certificate is P4. But I can see the certificate. I'm relying on, but the final certificate issued by MSMC is annexure P4 at page 9.
Looking for the latest trends in home furnishings? I got you. The trendiest of curtains curated by me. Ombre, sheer floral, chevron, damask, only on Myntra Home.
Now, my lord,
Yes,
this page 88,
yes,
this letter was there.
yes, just
But
see.
unfortunately, you did not controversy.
No, page 138, footnote 13. Page 138 of the paper book, footnote 13 makes an express reference to this letter. Then when our gentleman went over there to that office and we filed an
Which date he
RTI.
went over. RTI is being applied on 24th of November
obviously we went
25
over there. We
for the
found that
first time.
He was shown, but they were
Lord, may kindly, hold on a second. Lord, may kindly notice 3 dates. When the High Court was pushing them for a conclusion of argument, they say we have sent RTI. Lord, may kindly notice this date, 24th of November. Then 25th of November, they draft this affidavit that we doubt this certificate. And the High Court refuses to take this affidavit on record. 26th of November is the judgment reserved. It's a false plea, my lord, in order to seek a notice and a stay. And in the first round, they never doubted this. There is a finding by this court that they have not doubted it. My lord, para 25 of my lord's earlier judgment refers to this certificate. And they say respondent number 1 has never doubted this certificate. This is the finding which the High Court has read and delivered this judgment.
Government company,
No.
private entity.
Yes.
So, Mr. Diwan, the question will be that this Vijay Seth or whosoever has signed, this page 89, please.
Yeah.
Now, in a private company record if the letter is replaced or substituted.
No. See, this, I just tell you very simply, page 88. This document came on record in their rejoinder. They were the SLP petitioner. So this document came on record for the first time in their rejoinder affidavit.
This document was here, my lord.
Yeah, it was here, yeah. It was here. It was here in this court, and your lordships have referred to it in that footnote 13. Now, just see page 88. Page 88, they wanted to participate in the present subject tender. So they write to the Maharashtra State Mining Corporation Limited saying, please issue me a certificate. When we started reading this in the format to whom it may concern, and that format goes over to page 89 and it ends that this certificate is being issued at the specific request of for tender participation. The paragraph before that is completely alien to any such certificate being issued, because it says that I want to make an application to change my colliery and my washery. So that had nothing to do with it. Then when we examined it, we saw the actual certificate which Maharashtra issued.
Lord,
And
which
Maharashtra
date they examined?
certificate
The affidavit, Lord,
93.
Lord, kindly ask them which date they examined.
3 without that paragraph. So we were put to inquiry. Now, when our officer who made that affidavit saying that on the best of my understanding, because we put in an RTI, but there was no time for a reply, he was shown and he said that, therefore he said that to the best of my understanding and bona fide belief, he saw the letter, it doesn't have that. So they have inserted this paragraph, which is at page 89. Now, whether it's right or wrong, let the state of Maharashtra entity confirm before the High Court, and that's the end of the matter.
And waste another year and then say that the matter has become infructuous. In this process, they have nothing to lose.
Because we are asking Maharashtra State Mining Corporation Limited, which is a Maharashtra government entity, to confirm that this document at page 88, 89 is what they received with the paragraph at page 89 or not. That's all. That's all. We are not asking any private entity to confirm. We are asking whether in the books and the records of Maharashtra State Mining Corporation Limited. It's a government of Maharashtra undertaking. Manoj, it can be completed here. Just I'll just issue notice to them to bring the letter and finish it over here.
Lord, the financial bids have been opened in deference to the High Court judgment. And I'm L1. I'm 27 crore less than him.
The allocation of work of coal beneficiation and logistics. Madhya Pradesh Power Generation Generating Company Limited issued a tender for coal beneficiation and logistics. Petitioner, System number 1, participated in which the technical bid of list number 1 was rejected by the tender evaluation committee. List number 1 being agreed approached the High Court, but its petition was dismissed. The first respondent then approached this court. Why the judgment? 9th September 2025, this court allowed the civil appeal number so and so to the extent that, to the following extent, I have a set of procedures. I have 22. Para 22 to 25. 25. Next paragraph. The case was consequently remanded to the High Court. Was allowed in parts of the allowed this by this court in part. Case was consequently Bengal. High Court has wide influence judgment dated 23rd March 26. Accepted the claim of this number 1 and has declared him to be qualified in the technical bit. Direction has put in while holding so the High Court has in para 52 of the influence judgment. Para 37 of the influence judgment. Relied upon a letter dated 14th June 2024 purportedly written by Messrs. Hind Mineral LLP to Maharashtra
State Mining Corporation Limited.
Maharashtra State Mining Corporation Limited. A copy of that certificate is appended as a P3.
This is the request letter. P3 is a request letter, and in response to that request letter, P3 certificate is an actual P4. So in my request letter, that undertaking was there.
Relied upon a request letter, a request letter. The aforesaid request letter is appended as section P3 in the SEC paper. It may mention that the request letter was written to provide an experience certificate for the work of lifting and beneficiation of ROM code undertaken by as Maharashtra Mineral Mining and Beneficiation Private Limited. So being that as it may, the aforesaid letter was also placed on record in civil appeal number so-and-so, which was allowed in part by this court. The contents of the request letters were never disputed either by or by the Maharashtra or by the Madhya Pradesh Power Generation Company Limited. It seems from the report that after the remand by this court, the case was heard from time to time by the High Court, and judgment was reserved on 26th November 2025. The petitioner claims to have filed an affidavit a day before thereto, that is on 25th November 2025. And in para 8 thereof, the petitioner is stated to have averred as follows. In para 8 and 9. 8, 9 and 10 point, 10 crore, 8, 9 and 10. That's well. We are not sure whether this article is a part of the judicial record or not. Number 1 who is on caveat, so it's also denies the filing of this affidavit. They have responded.
They say, Lord, RTI was applied on 24th of November.
You have filed a response to this affidavit.
No, my lord. In fact, the High Court never took that affidavit on record. The High Court refused to because it was found to be a dilatory tactics.
They filed a response which is at page 6 of the additional documents.
And one told is neither their affidavit was taken on record nor my response was taken on record by saying now I have heard the matter, nothing new, and judgment was reserved. Both documents may record this statement. Both documents were not taken on record.
Not sure whether the affidavit was taken on judicial.
It was found to be a dilatory tactics.
In such circumstance, after taking notice of the contents of the affidavit as reproduced above, and in light of there being a factual issue, refiling of that affidavit and taking thereof on record, we grant liberty to the petitioner to file a review petition before the High Court. So, we request the High Court to examine this aspect, and pass appropriate order. It is clarified that we have not expressed any opinion on merits of the allegations or contrary. Absolutely.
Yes, at my request, would your lordships implead Maharashtra State Mining Corporation Limited? Yeah, so that they have to only come with the file, that's all there is.
That High Court will take a call.
Sorry?
It's for High Court whether to,
No, High Court can take that call, but I'm saying let us do it now, it will get over within a week. At my request of
this is again,
This line exactly you will argue before the High Court now.
All
They
right.
have permitted the High Court to entertain.
All right. No, nothing.
Lord, again, Lord, some cost should be considered, taking a factually incorrect plea only to drag the matter so that they make it infructuous.
Thing you will argue before the High Court.
So this last one, that GV can
You argue.
So, Lord, their SLP is dismissed with these observations.
Not this. Dispose.
Please.
Item 38.
Lord, I will just have a look at page 31, 41. What is the reason for confusion? Your lordship permitted.
Oh, PMK.
election is after tomorrow. Just see election says.
My prayer is for freezing. Other than freezing, everything is written in the order. Freezing is just noticed in one paragraph and not decided.
Election is day after.
Pondicherry, we are not even now. Obviously, Pondicherry is closed now. Please see page 41. Just see.
Even Tamil Nadu, because.
So Tamil Nadu is not open. They will decide tomorrow day after. Just let me argue. Page 41, if your lordship will just permit me, Lord. 41. Forty-one is Lord 30th of July 25. Mango symbol allotted to an unrecognized registered party. Page 41. On 30th of July 25. Don't you have that? Now, Lord, please see 121 is the Delhi High Court, which is 4th December 25, about 5 months thereafter, at 153. The Delhi High Court judgment Lord of 4th December, after this symbol allotment issue had happened and disputes arose in the party, 153, paragraph 37. This court, Lords have para 37, bottom of the page. This court also records the submission made by the learned counsel for the ECI that ECI shall not decide upon any page Lord 153. At 153. Order starts at 1 to 121 Lord, that is 4th December. 30th July is the allotment of single to the party.
153, this court also notes, sir.
Yes, this court also records the submission made by the learned counsel for the ECI that ECI shall not decide upon any controversy with regard to recognition of either Ram Ambumani or Ramadas as the president of the party. Accordingly, in view of the settled or discussed here and above, and upon consideration of this advanced the party before this court, it manifests that ECI has no power or jurisdiction to give any finding as regards internal disputes emanating from rival factions within an unrecognized political party, as in the case of the petitioner political party. Further, ACI as such shall not recognize or recognize a rival faction or any claims that may be raised by any rival faction. So, mango Lord symbol is as of today floating. Now, Lord, I go to the writ court first round. I say, please freeze. They don't. I come to your lordship. Your lordship said you should have made this in the civil suit. So I go to the civil suit. Your lordship's order of Lord 23rd March is at 260. At 261.
But the our problem with the time, essence.
No, it's only to be frozen, Lord. The symbol is allotment is yet to happen. I'll tell you, Lordship, what is the, I'll show the symbols order.
Would also be happy that your political party, if at all you there's some candidates succeed, ultimately credit will come to you only.
No,
You are
but it
founder.
can't. I'll tell you, Lordship, problem. Problem is who will get mango is completely hanging in the balance. Mango, if it is a free symbol, then it will go, Lord, either by draw of lots or first come, first serve. The election commission has to take a call whether it be first come, first serve or draw of lot. Now, mango, if supposing I am first come, first serve in one constituency, they are first come, first serve in the other constituency, then mango will be one with me here and with them there. This kind of a thing can't be allowed to be entertained. EC says, I don't want to get into this. This impugned order also says, go to the EC. What has the EC got to do? EC has to take a call that this is no more a free symbol. That's all that they have to say. If it is not a free symbol, it obviously deserve. If it is not free symbol, then it can't be given to anybody. EC says in this impugned, just see the impugned order. EC says it is a free symbol. Just see that, Lord. In the impugned order, if your Lordship will see, if your Lordship will see the impugned order starts at page 1, and the EC says at page 24. No, sorry. EC petition, EC statement is page 16. Sorry, I'm sorry, Lord. Page 16, page 17, para 16. Just see page para 16 at page 17.
In any case, now as per civil court also, you can approach the election commission.
No, Lord, but election commission has to, your Lordship may say, let it decide it before the symbols are allotted. That's all, I have no difficulty. Election commission, Lord, your Lordship will recall Mohinder Singh Gill, 7 judges said that if there is a dispute, election commission can't keep quiet, can't just wait, can't just not decide, can't just give a, even if a perfunctory hearing is to be given, give a hearing. Just see at 16.1, what does the election commission say? He fairly argued that the allotment of symbol is not a matter of right, and it was a right in rem, and that election commission has nothing to do with the internal disputes in the party, and that it is open to the parties to seek for free symbol. So if it is a free symbol, Lord, it will keep floating from one constitution. Let the election commission decide by tomorrow. I have no difficulty, Lord. Let the election commission decide by tomorrow.
Submission of election commission is that PMK has been allotted mango, so if you feel that you are a faction, you can ask for a free
No,
symbol.
that they can't do, because in the Delhi High Court they have taken a stand that in this dispute we are not getting into. This dispute will be decided by the civil court.
Dispute, they are not deciding. If you get an injunction from here that I will be treated as the president, or
I don't want that. I'm sorry, Lord. I'm not seeking, today I'm not seeking that at all. I'm only seeking that this
what
dispute.
the election commission would have been in a better position.
I know,
a lot.
but
You
today,
get an injunction against them.
today,
That your
today
son will not be treated as the president of the.
no, Lord, let me.
He wants to destroy the party
No, Lord.
by
let me-
asking for freezing when the election is 2 days later.
He
let-
created.
I don't understand that.
Who is the real party, Lord, is the real.
Election is on 9th.
He is your father.
We have campaigned for mango.
Who is the real party is the question. I'm not
That's
wanting
what
the Lordship
but
to
it
get
can't
into
be
that.
an election.
Father hai.
Election is on 23rd April.
This is a case, Lord.
Election is on 23rd April, my Lord.
No.
Election is on 23rd April. The symbol allotment has yet to happen. It will happen day after tomorrow.
What they have to do? The age, what is the age?
Election Commission can't take the stand. I'm sorry.
And there's someone else behind him who's probably involved with this.
Actually, my lord, it's a case. The plaintiff is the father of this son who is the real respondent. He is 88 years old. He has filed a suit against the son. He feels that the son has now taken over the party. That's, my lord, his grievance.
No,
According
that
to
is,
us, there is somebody behind the father.
It's a very contra-Indian political scenario. Because every father wants the son to take over the party. This is where the
It's the
father
other way.
doesn't want the son.
The father doesn't want to let go. Father will not let go.
I don't want to for the time being, because civil court will decide that finally.
Underestimated his capacity.
And he has filed
I
an
have
appeal
started-
against the trial court's order. He
I
has
have
not gone to the High Court. How can you come to the Supreme Court?
I have founded this party. This party, Lord,
That's
your
the real
Lordship,
point.
your Lordships permitted me to go to the trial court by filing an application.
So just two facts, my lord, and I'll leave it at that. Today, my lord, the question is whether it is a free symbol or not. If it is a free symbol, then I have applied earlier, then also I'm entitled to get it because it has to come on first come, first served basis. But Election Commission can't say that they will be given the mango.
Mr. Qasim, the point is that if you really don't want your son to win on any ground, then probably you will have to go to the voters. I think you need to activate yourself.
But voters also, to go to the voters, Lord, I have to have a symbol. I can't go to the voters by
Symbol and go.
no, but symbol, which symbol, Lord? The problem is if he gets mango,
Free symbols,
but
whatever you want.
no, this mango can't be a free symbol. Is all that I'm saying.
You want
And-
a father figure free symbol, you go with a
So
father.
Lordship may say so, but mango can't be given to either of them.
These
That's all
can't be
that I'm
matters of an interim order.
Your
Symbol,
argument
these-
politically is destructive. Because tomorrow if you win over the party, you won't get the mango symbol because
Correct.
you are giving up the
That's
mango
right.
symbol for PM.
I'm not giving up. It's only
Don't
temporary.
give up the
No,
mango.
no, I'm
symbol for
giving
PM.
up temporarily, Lord.
Just
It can't,
because you want to
it can't be
convince
given
yourself.
to him. It can't be given to me. Election Commission, Lord, Election Commission has taken, just see the statement of the Election Commission at 157, Lord, 153. Election Commission in the Delhi High Court has taken the view that we are not going to decide who is the real political party. If the Election Commission has already taken the view that we are not going to decide who is the real political party, then obviously it can't give a mango to either them or to us.
There is a difference between leadership of a party and a party.
And
The Election Commission recognizes PMK
Yeah.
as an unrecognized registered political party,
but Lord,
which has been allotted the mango symbol.
I appreciate,
Now,
Lord.
who is the
Who will,
president of PMK?
who will nominate the
Is-
candidates?
Who will nominate is
Who
the
will-
matter in dispute.
Yes, so who will, so if I say, Lord, if the party's position is in dispute, this impute order says I can go, your lordship may say, let the election commission decide by tomorrow, that's all, Lord, just have a
It's
look
a
at what
question
the again.
of election commission
Election
deciding
commission,
tomorrow.
no, impute order also says so.
The impute
But
order
they
somebody has said
can't,
so.
they can't leave me in the balance,
Absolutely
right,
wrong.
in the balance like this.
Judgments are taken finality 15 of symbols order completely does not allow election commission.
Your lordships in the last order said that aggrieved party can't.
Like in the High Court, you challenge this order before the High Court.
You should have gone to the High Court if you.
Lord, difficulty is, Lord, the symbol will be notified day after tomorrow. What will I do?
Symbol will be notified. Election is after 2 days.
Tomorrow, go to the High Court tomorrow.
Well, very well, your lordship permit to go to the High Court tomorrow.
Impugn order has been passed by the civil court, city civil court tonight. We are sure that this order is revisable before the High Court. The order, the impugn order can be challenged before the High Court in a through a revision petition.
This will be a civil appeal or something, yes.
I should decide by day after. I'll file it tomorrow.
Miscellaneous.
It will not be a.
Miscellaneous.
it will be a-
This is an SLP against the trial court order.
227 also you can. No.
No, my lords, it won't be a 227 because it's not an authority. It won't be
High Court to appropriate proceeding.
appropriate. That's true.
And your lordship will request the High Court. Otherwise, Lord, it can't be made that we will be frustrated completely.
To entertain the petition owing to the urgency,
My lords,
shown on
my lords, in the middle of
by the party.
the parties are going to be in the court at this rate.
We are not saying party.
Campaigning, but they'll be.
We are not showing urgency on behalf of the party. We are
Just
saying
what happened in Pondicherry, your lordship?
My learned friend has.
They
said
were
it for
given
so
mango, they
long.
withdrew all their candidates in spite of getting mango. That is what they are doing to the party.
My lords, can I
They
just make?
withdrew all their candidates in spite of getting mango in
Because I
Pondicherry.
don't know whether
That's
the
why it is
vocal
important
power
that
is
they
so
can't
much that
ruin the party like this.
How's that? No. আমি বলছি হাউস দ্যাট নো এক সেকেন্ডে 12টা বাজিয়ে দেব
গুন্ডাগিরি শেষ হবে এবার পাল্টানো দরকার চাই বিজেপি সরকার
symbols order allows a party to use a symbol for a period of 6 years after being unrecognized. And my lords, the High Court has already held that it is a civil suit and they have accepted that order.
Deeply obliging.
This question of every time coming here and saying, oh, let it now be decided. My
Lord,
lords,
order be given today
we are
itself.
going to
that
court.
argument will raise before the High Court.
Lord, order be given today itself.
All right, item 39.
Lord, order be given today itself.
39 period in that case.
Lord, order be given today itself, Lord. Deeply obliged.
It's the last order.
Lords, in 39, I'm for the pediatrician. Your lordships had issued notice to the doctor to explain. I filed an affidavit. My report is exactly the same, my lords. I just saw her for a few minutes in the beginning, and my report is exactly. I think maybe there was some other report shown to your lordships, which is why your lordships.
That we have seen.
Yes.
Both the reports were shown,
Lords.
not any other report.
My lords, may I submit, my lords?
I'm just saying, as far as the doctor is concerned, that notice may be withdrawn, my lords. I'm an 80-year-old pediatrician. I'm one of the top pediatricians.
Draw the notice like this, Mr. Gopal. We'll first like to examine everything.
Yes, of course. Please, I'm just saying for us, as far as I'm concerned, I think your lordship has shown some other report which was, which was.
Mr. Secretary.
No. Let me just.
Reports which are on record.
No, let me. I'm just explaining.
Before we go into the controversy, would your lordships like to hear from the SIT chief, my lords? She is
Yes,
online, my lords, and they are, my lords, ongoing with the investigation. They have completed major parts of it. And if your lordships will give them two more weeks, my lords, she's online also. I had spoken to her. My lords, on purpose, I did not ask her about the investigation.
The investigation to be completely smoothly. it
Please,
should be
my lords.
completed. Other issues are there,
Yes.
very serious issues we
Yes.
would like to examine.
Yes.
We will not drop a single issue out of it. And most important issue will be this constitution of this committee. Who is doing it at whose instance it is being done?
My lords, my prayer would be your lordships may consider hearing from the SIT chief, and your lordship may consider granting them 2 weeks' time. They asked us if they need separate lawyers. We said we are appearing for the state. We'll put their request, and their report should come to your lordships in seal cover so that your lordships are satisfied about the investigation. But my lords, after that, my only request is your lordship may take up the other issues after the SIT submits their investigation report before your lordships, my lords.
Lord, I have no objection. Let it come after 2 weeks. No problem. Lord, I have no objection. I am not against anybody.
We are not dropping a single issue.
I agree,
Rather,
Lord.
we would like to examine larger public
Lord,
interest.
you may keep it after the
This
constitution bench is over.
instance is an eye opener for the whole country,
Right.
in fact.
Lord, some guidelines may be necessary. Your lordship may keep it, Lord, in the last week of April. CB will be over by then. Then, Lord, time can be given. Only one more thing I want to say. Lord, the SIT has filed an application that the child should again be asked to do a TIP. Lord, that's not, she has identified. You can't have another TIP again. They have filed an application, my lord, that should not be entertained at all. Can't have a TIP again, my lord, asking the child again to go through this trauma.
My lords, the SIT chief is online. I'm requesting for them to be unmuted. Otherwise, the conversation I had with Ms. Kala Ramchandran was, my lords, that they have not interacted with the child at all. They would like to interact with the child because so far they've only interacted with the parents.
Can they go in,
They will go, my lords. They will go to
They
the
can
home.
come to my house, no
Yes.
problem. No problem.
Mr. Rohde,
Yes,
they will come to the house.
yes,
They will come in civilian dress.
yes.
In the civilian dress.
No problem.
My lords, they also are requesting, if your lordships will permit, they would like to go with a child psychiatrist from AIMS because the child is so little that.
But nobody should disclose that who is
Yes.
who before the child.
Please,
Yes.
my lords. Please, my lords.
They should sit there, my lord, have a cup of tea, like friends.
Madam
And-
Kala Ramchandran,
And any TIP, my lord, should be by photograph, if at all they want to show something. Otherwise, not necessary. She has identified. Why should we have this again?
Camera.
And then there are two more issues, my lord. Your lordship has said that it should be a male magistrate, a female magistrate in the last order. My lord, the magistrate continues, my lord, to be a male magistrate. That is contrary to lordship's order number 1. Number 2, a bail petition has been filed. Now section 6 has not been added. If you don't add 6, the gravity, my lord, is completely diluted.
but that is a matter of investigation now.
No, I'm saying if bail is decided, my lord, without 6. They have dropped 6 from the FIR. Your lordship said, observe that day, it's a case of 6. How have you dropped? So if
the SIT find that yes, an offence under 6 or any other provision
Yes.
is also made out,
yes,
they are bound to.
correct, but then that bail should be deferred. If the bail is granted tomorrow in the absence of 6, my lord, then it will be too late to add 6 and then
That we can understand.
kindly, my lord, take care of it.
My lords, Ms. Kala Ramchandran is on the screen, my lords.
Madam Kala Ramchandran, can you hear us?
Yes, sir. Yes, sir.
All right. two things, that how much more time you require for your SIT require for investigation?
Sir, we have conducted the polygraphy test of all the three accused on this Friday, sir. And
দাদু কই? এই সাবধানে সাবধানে। দিদির সরকার বাংলা সবার বাড়িতে খাবার জলের কানেকশন পৌঁছে দিচ্ছে, আর আমরা সেই জল নষ্ট করছি।
দিদির 10 প্রতিজ্ঞায় উন্নয়ন হবে আবার বাংলায়।
BNSS, the mother has been interacting with everybody else. We feel that it is important to talk to the child.
Do one thing, please. This is our request and suggestion both, that three of you in the SIT, and along with any child counselor or any doctor, whomsoever you want, you all of you go please civilian dress, and you just go and to the residence of the child, to the place, and just there interact with in civilian dress. We don't want the child to have any psychological impact of the police dress or the doctors wearing any white coat or any that kind of thing. So you please, all of you go in the civilian dress. You have a cup of tea with the parents, and during that process, then you can continue with your interaction.
One more point I wanted to say, sir. The request for the TIP has not been made by us. It had been made earlier by Gurgaon police when they were conducting the investigation. We have not requested for any TIP, sir. TIP, Mr. The test investigation parade, I think Mr. Rodki made that submission that the SIT is insisting for TIP. So she's just responding that TIP is not.
Fine, so that TIP will not may be disposed of. She has not asked. I think that's gracious enough. They are welcome to come to our house in civilian dress. We'll have a cup of tea. They will engage in a friendly manner. They will not speak to the child. No problem. And that bail part will also be taken.
Today only we are confining to this aspect. Rest of the issues we are keeping.
Right.
Try to examine them.
Well, may I just say that lady is present in court also, just in case because your lordship said
He need not be present.
By you.
very well. So her affidavit may be taken on record.
Affidavit is already there on the court.
Yes.
She is Dr. Babita Jain.
Yes.
Affidavit is there.
In fact, the MLC was registered on her reference. When she examined the child,
I will look at it.
she initiated the process.
Need not come. Who's stopping you?
In pursuant to the order dated 25th March 2026. Compliance affidavits have been filed by the following. 1I, the Child Welfare Committee, Gurugram. 2I, Mr. Shekhar Vidyarthi, former Commissioner and Secretary to Government of Haryana, Women and Child Development Department. 3I, Dr. Babita Jain, Principal Director and Head of the Department. In bracket Pediatrics, Health Care, Gurugram. Then next affidavit of Inspector Suman, who was posted as SHO in bracket Women, Sector 51, Gurugram.
Because he has to go in.
Then Inspector Narendra, posted as CIA in charge, Sector 43, Gurugram. And lastly, Dr. Kavita, Assistant Commissioner of Police, CAW, Manesar, Gurugram. Next paragraph. As of now, we do not propose to refer to the contents of these affidavits and express any opinion. All the issues,
Next time you have somebody else.
all the issues
Please take.
raised in our order dated 25th March 2026 and or other related stroke allied issues that may arise for consideration will be dealt with at an appropriate stage. That's problem. As of now, we are mainly concerned with completion of the investigation by the SIT constituted on 25th March 2026. Then say, Madam Aishwarya Patil, an additional solicitor of India, representing the state of Haryana, on instructions from SIT, submits that 1 week more time, 2 weeks time is required for completion of the investigation. Ms. Kala Ramchandran, IPS, Additional Director General of Police, who is the head of the SIT, has also appeared online, and she too has requested to grant some more time for taking the ongoing investigation to a logical conclusion. We find the request of the SIT to be just and fair. Consequently, the SIT is granted 2 weeks more time to complete the investigation. Next paragraph. At this stage, it is pointed out by Sri Mukul Rohtkar, learned senior counsel for the petitioner that SIT wants to interact with the victim child. In this regard, we have impressed upon Ms. Kala Ramchandran that all 3 members of the SIT, along with doctors, stroke, child counselor, if any, will go to the residence of the child stroke her parents in civilian dress, without disclosing their identity, and may interact with the child without disclosing their identity. So, could this Ms. Kala Ramchandran has agreed to. Ms. Kala Ramchandran has agreed to this suggestion. Shri Rohtkar has also no objection on behalf of the parents of the child. Next paragraph. Since the inclusion or exclusion of since the issue as to nature of offense in bracket S alleged to have been committed on the victim child are yet to be prima facie determined by the SIT, the courts concerned are directed not to entertain bail application of the accused till the charge sheet is filed. Any other internal direction at this stage?
Female magistrate. Female magistrate. Your lordships have already ordered. There's a magistrate, should be a female magistrate. Currently, the judge is a male magistrate.
It will be there. A woman. We are quite sure.
We will inform your lordship's order is there. We will inform the court. Lord, the application for TIP is rendered infructuous because they don't want it. There's an IA, my lord. IA is 27476. CRM.
Is accordingly disposed of as having become infructuous. Post this matter.
May I make one more request?
On 4th April, Friday.
May I make one more?
May.
April is not
6th of April. They are wanting 2 weeks now.
Yes, Malad. Malad, I will make one more request.
We are 6th April. If you are sick with them 2 weeks, we can have it last Tuesday in April or first Tuesday in May. Lord, the CB will be over.
All right, if you take it on then 27th April?
Yes.
27th April.
Malad, I was requesting for one more submission, one more direction, Malad. Would your lordship consider, Malad, that the AIMS may spare one, because I'm appearing for Haryana government, Malad. AIMS may consider sparing one, Malad, child psychiatrist of expertise for Malad for this exercise.
Keeping in view, since the SIT may require expert assistance, assistance of some eminent expert,
child psychologist.
Expert or child counselor,
Child psychologist,
child
counseling.
psychologist, counselor stroke psychologist, we request the director on Indian Institute of Medical
great.
Sciences to provide such facilities
I'm grateful.
to a site.
Lordships. I'm grateful, madam.
Very good.
Great. 40.
Well, it's
In terms of the previous direction, we have filed affidavits. We have the extra copies, cannot be on record. We have constituted two separate committees. One is that for legal studies. The other one is an expert committee. Both the committees have been constituted, and from the central government, we have issued directions to all the concerned states and other bodies to meticulously comply with the directions and follow it. We can hand over.
Once the experts are there, we are going
Yes,
to.
this way. We can hand over the copy of the affidavit for.
Also filed an affidavit today morning.
It's all right. You please also, from our side, you just impress from and you convey to the committee to examine not only their examination or visiting.
Yes.
Should not be confined or restricted to 8 standard only.
This,
Let them go up and down both.
for all the purposes. We will do it.
well, it's,
May
may I
I
just,
said that there are certain issues even with respect to, we don't.
First one, kindly turn to page number 10. That is the. Our affidavit is not given.
This planning.
I'm giving our affidavit copy. Give it.
That is NCRT.
You kindly have this one. It covers both.
Say, MCERT has placed on the board a compliance affidavit,
Kindly take union affidavit which has both the orders.
along with which a copy of the order dated 16th March 2026, issued by the Ministry of Education from a Department of School Education and Literacy, has been appended. While this affidavit, a 3-member committee comprising one Honorable Justice Srimati Indu Malhotra, former Judge of Supreme Court of India, 2 Shri K.K. Venugopal, Senior Advocate and former Attorney General for India, and 3 Shri Prakash Singh, Vice Chancellor, Hemati Nandan Raguna Gadwal University. There are 3 of the government order further clarifies that the committee will collaborate with National Judicial Academy Bhopal for the purpose of finalizing the curricula of class 8 as well as higher grades in tandem with NCERT on the subject of legal studies. What is the other thing?
That's in the union affidavit. That is there at page number 10. That is notification dated 2nd April, reconstituting expert committee.
The CERT has also issued a notification on 2nd April 2026. A copy whereof has been appended in the along with the compliance report filed by the Union of India through the Ministry of through the Department of School Education and Literacy from a Ministry of Education, whereby a high-powered committee has been a high-powered committee for preparation of the national syllabus and teaching learning material committee in bracket NSTC has been reconstituted. The details of the reconstituted committee comprising 14 distinguished members.
It's 20, my
20.
lords,
The
20,
next
it goes
page.
to the next page.
20.
20 distinguished members, including Ms. MC Pant, former Chancellor of National Institute of Education, Planning and Administration, being its chairperson, and Professor Manjul Bhargav of Princeton University, being its co-chairperson, besides a member secretary, whom I have been duly nominated. So we take both the documents on the court, both the orders, stroke notification on the court, as also the compliance affidavits. How much time approximately they will take? We are not going to examine whatever they will decide, because we wanted some experts to examine.
They'll start working immediately on this.
My lords, we have something to say. We are the three authors, Mr. Datar and Mr. Deepak are also online. We have filed our affidavits where we have given our explanation, because I think the observations that have come in your previous two orders have, in fact, apart from directing blacklisting of us for the future, has also cast some grave doubts about our learning, our knowledge, etc., etc. So we have filed applications, my lords, as well, which we understand was filed after 11 a.m. on Saturday. So I don't think that will be
These are
before.
not before us.
Yes, I understand they're not before you, which is why if your lordship would list it for us to address your lordships on that, because now this process will go on, that chapter stands substituted, new books will come in, etc. But we believe that we have something to say on that.
Are you defending your action or?
In para 8 of your lordships. We are giving a context, and we're showing your lordships the new pedagogy that's come in from the national education policy, including how other issues, because your lordships, I was present that day when the mentioning happened, the Indian Express article was shown to your lordship saying that judiciary is being singled out. Class 7, class 6, all the textbooks do deal with issues and hurdles and obstacles and challenges that are faced by the legislature, by the election commission and the executive. All of those have been dealt with. We wanted to show your lordship what the process is that was followed. These are not fly-by-night academics, my lord. These are academics with a lot of street cred. I mean, the author, in fact, has appeared before your lordships, has been an advocate of this court. So,
Here, Mr.
your
Datar,
lordships,
my lord.
once that is placed, your lordship may consider it.
Mr. Datar appears for Michel Dinenu, my lord. He's online, if your lordship may please hear him, my lord.
My lord, your lordship in para 8 has directed us to file an application with an explanation. So that has been filed. So lordship may, as Mr. Gopal said, anytime convenient to lordship, we'd like to put forth our explanation.
Michel
filed on behalf of whom?
Michel Dinenu.
Professor Danino, Michel Danino.
Professor Michel
Yes, and I
Danino.
have
I am
filed it on
for
behalf of-
Alok Prasanna Kumar, and Mr. Deepak is for Suparna.
बेबी फॉरेन चले?
चलो, कोई अच्छी डील मिली क्या?
मेरे पास एक बंदा है, हो जाएगा। मेरे पास एक बंदा है।
मेरे पास दो बंदे हैं।
ओके,
लेट्स गो। इसके पास एक बंदा है।
उसके पास भी एक बंदा है।
मेरे पास भी एक बंदा है।
अपने पास भी एक बंदा है।
I also have one
बंदा, ब्रो एक्स।
वैसे
बंदों की चेन तोड़ो, स्काई स्कैनर ही सॉलिड बंदोबस्त है।
Search all your favorite travel sites in one place. Skyscanner, travel ka ultimate hack.
And senior counsel that they have filed applications on behalf of Professor Michel Danino and Ms. Suparna Diwakar and all Prasanna.
I have filed it on behalf of Mr. Suparna Devakar.
Mr. Sai Deepak is online, my lord. Mr. Sai Deepak is a fan.
I appear for Ms. Suparna Devakar.
And Mr. Gopal is for Alok Prasanna.
I'm for Alok Prasanna.
Mr. Saidipur, you are filed on behalf of whom?
Suparna Devakar.
The lady there.
Suparna Devakar.
Then say Mr. Datar, Mr. Gopal Singh and Mr. Saidipur, senior counsel, point out that they have filed their respective applications on behalf of Professor Michel Danino, Ms. Suparna Diwakar and Mr. Alok Prasanna Kumar, whom a reference has been made in para 8 of our order dated
11th March.
11th, dated
11th March.
11th March 2026, along with certain directions issued against them. Issued in respect, in respect of them. These applications have not been listed today. It is still directed to list those applications from a subject to curing of any defect on so and so day. On so and so day. Post this matter
Lordship,
for further consideration.
Wait.
uh,
Lordships are giving a date?
Lordship, there is a request, it is a serious offense and
Please
guilty
don't
must.
don't file any, no, we will not allow anyone to become party to this proceeding. Application for impediment as intervener, all applications are dismissed.
Great.
We will not allow, this is not, and we don't want to, anyone to take unnecessarily advantage and settle scores.
Allowed is
Consider
giving the
getting
date
a
of 2 weeks.
specific date, Manoj.
Specific date after 2 weeks if it's possible. 2 weeks or later.
We propose to hear three of them, and
Yes.
whatever orders are required, then we pass.
Great.
First things matter.
Milos, I beg to appear for the petitioner. Here, Milos, as per the settlement which was arrived at between the parties, Milos, Lordships had appointed Justice Shakdar as the mediator. There were criminal cases lodged by the other side against me. I had to pay 3.15 crores in installment. The entire payment stands now paid. The entire amount has been paid. And Milos, the only difficulty now is, Milos, there is one issue which the other side keep raising. I don't know why. Milos, there was a transfer of shares to be done. Share transfer forms are lying with the registry. Since the payment has been made, those share transfer forms can be given so that the share standing in the name can be transferred in the name of the petitioner. Now, my lords, there is an issue of valuation of these shares. Sorry. First April order.
This was the first April.
First April
last
order.
year.
Yes, 1st April 25 order, last year.
Say it is stated by the Board of Overall Learning responsible for the petitioner and is duly acknowledged by Mr. Basant Land Senior Counsel presenting the
Yes,
complaint.
one submission after Lordship dictated.
You are for the complainant.
Yes.
Presenting the complainant that as per para 9 in bracket 1I and 2I of our order dated 1st April 2025, the petitioners have paid a sum of this 3.0
3.15.
3.15.
2.15
3.15 crores.
3.15 crores. Yeah. As per the said order, the transfer deeds,
Yes, my lord. The share transfer forms.
transfer forms
Yes, my lord.
for the regarding the share of regarding transferring of share
Yes, my lord.
in favor of the petitioners are lying with the registrar and record division of this court.
My lord.
Let those forms be accordingly released.
To the petitioner.
Stroke handed over to the petitioner.
My lord.
To the petitioner. You
Yes,
want
just one submission. They paid the money, no problem with that. The same order, Lordship may kindly see para 4 of the same order. What your Lordship just read, 1st April. The petition, may I just read that, para 4. The petitioners have agreed to bear the burden of tax liability that may accrue due to the above transfer based on the valuation of shares. The petitioner shall be responsible for getting the values assessed. Now, my only request is this. As of now, we don't know what the valuation report is. Now, what tax liability may come in future. So Lordship, while disposing it off, my humble request is please record in the order, record their submission. I'm sure they wouldn't have a problem with that any tax liability resulting of this transaction of 3.15 crores, according to them, is the value of the shares which I have transferred. That should be borne by them. So I am 80 years old. Later, after the matter is disposed of, I should not be faced with any difficulty.
Can I indicate something?
Yes.
And Lordship Chief Justice may guide us. Now, if you say 3.15 crores, the income tax department will say 30% of it immediately. It is not the valuation of the shares. I have valued the shares, and according to the valuation, 34,000 was the tax liability, the check I have given to them. Now, they can't say, now you pay tax of 3.15 crores. This is what the intention is today. But just have a look at the settlement.
Yes.
Settlement is that the shares will be valued by me, and the shares have been valued, and the tax liability. So, Lordship.
Tax liability, income tax probably they can't be burdened in terms of para 4.
Would your Lordship kindly see the mediation report? That's exactly the understanding. Can I just show the mediation report?
Just have a look at the
I'll
mediation.
just read that. Court Master, do you have the mediation report? On this matter?
I have a copy.
Yes.
Yes. I have copies. I'll hand it to
Yes. Just one clause I'll have to read. Manoj,
Yes, yes. Please do. No
Yes.
problem. Just have the mediation.
The mediation report, page 4. This one? Yeah. Page 4, it starts at page 3, Lordship may kindly see. Page 3, bottom, I'm assuming this page, same page number. Page 3, para 2, after much deliberations, Lordship got that one? Para 2 of the mediation. This is the mediation report. After much deliberations, parties have arrived at a mediated settlement in the matter.
It looks like this.
On the,
Yes, yes.
my lord got that, Manoj?
That's right.
Yes. My lord, just Bakshi has got that. Para 2, after much parties have arrived at immediate settlement in the matter on the following terms. Will Lordship kindly straight away come to clause 3. Besides the joint and several obligations undertaken by the petitioners, that is Mr. So-and-so and his wife to pay 3.15 crores, they shall also bear the burden of tax liability that may accrue based on valuation of the subject shares concerning WTPL based on Rule 11A of the Income Tax Rules 1962. The petitioners will reimburse the tax liability that may befall on respondent number 2, that is me, Mr. N.K. Taneja.
This will
Now, one second, Gaurav, just give me 1 second. Now, the para 4 of your Lordship's order is only reflecting this understanding. The actual settlement is this para 3. Now, here it is categorically stated that they will reimburse whatever is the tax liability. Now, today they can't go back on that. That's all I'm saying. Now that is my first submission is on tax. Second submission, my lord, that I'm sure my learned friend will not have a problem with. Lordship may kindly come to the same mediation settlement, Roman number 5.2, V.2. So what Honorable Judge Shakdar said is, likewise, as the criminal proceedings are concerned, parties are agreeable to the same being closed. Parties will endeavor to seek appropriate orders from the Honorable Supreme Court with regard to the same. In the alternative, if so directed by the Honorable Supreme Court, appropriate application will be moved before the concerned court. Now, I have footnoted the 2 FIRs in this thing. My request is, subject to what your lordships feel, instead of relegating us back to the concerned court, lordship may quash these. One is against me, one is against him.
That is all
So
right.
there
are 4 proceedings. We have given a list.
whatever the proceeding
Yes.
is, but now this tax liability, my lord. So what I was reading is the order. Order only reflects this understanding. This understanding in front of the mediators categoric, as they'll reimburse any tax liability which is under Rule 11 of the income tax rules. So now today when I entered into settlement, I factored that also into account.
Lordship may extract this as it is. If my learned friend says whole 3.15 crores is to be taxed, it can't be. It only on the taxation of shares. Now transfer of the shares, the income tax may raise a demand. If it raises a demand, I will satisfy the income tax authorities. But it can't say now that 3.15, the last line my learned friend is relying upon, the tax liability. I have said if there is a share transfer, the share transfer under 11(2)(a), whatever is the value of those shares, if the income tax authority says it's 30 lakhs, 40 lakhs, 1 crore, the tax on that I will bear. But you can't say now that you pay tax on the entire 3.15 crores because it's very clear the tax liability will only accrue on the valuation of shares.
With utmost respect, Milord, that
This
is
is
the
not fair,
understanding.
Milos, because it
That
means
is
that
the
I'll pay
understanding.
1 crore more, Milos, because there is 30% straight away tax.
Now, please don't ask us to send you again to mediation.
Yes,
No, Milos, Milos, this was not the understanding, Milos.
No, my instructions are that was a categoric understanding.
No, that's not
3.15.
correct, Milos.
Now, this is written there. I'm only reading what is written there, Milord.
No, that's why it's valuation of shares only, Milos.
because
Because now it's being smarter, Milos, because now it says, I who paid me 3.15 crores, income tax authorities will ask you from where did you get it? You will have to say this is under the settlement. Income tax authorities will say whatever tax as per the settlement you have to pay. But on the taxation of the share transfer, yes, I have to bear the responsibility. That's very clear from the settlement.
Sorry, the last sentence, my lord. Now, I don't know
That's
who's
not
being
fair is
smarter,
all
but
what I'm
the
saying.
petitioner will reimburse the tax liability that may fall on respondent number 2, Taneja. 3.15 crores is mentioned just before that, and after that they mentioned the tax liability. That was a categoric understanding based on which the settlement was entered
That's
into.
not fair.
There was a complaint against them that anticipatory bail, protection from arrest.
Resolve, Mr. Agarwal.
Milos, that's
Yes.
why, Milos, your lordships can send us back to the mediator, but I think Milos very clear that I can't be asked to pay more than 1 crore now because income tax is at 30%. My learned friend, is he saying that entire 3 crores is taxable or not? Let my learned friend answer that. Then the first sentence becomes redundant. My learned friend is now saying you have paid me 3 crores, pay 30% or 40%. 3 crores will be 42% of income tax liability. Now, is it clear, Milos? Lordship may read the entire settlement. Is it, Lordship, why will you write that it is on the share transfer, Milos? First he says, only on valuation, Milos.
Because sorry.
No, this is being
Even the
smart is
valuation
what I'm
report you've been asking for the last 6 months, we've not got the valuation report. They have not provided the
saying.
valuation.
On
report.
valuation,
There cannot be any enrichment on the basis of tax liability,
Yes, sir.
right?
Absolutely.
So it has to be seen what is the liability which is affixed on you as an assessee by the tax department
here only
transfer
Yes.
under Rule 11.
on the valuation
Yes.
also.
That is why a clear distinction was made
Yes.
from 3.15 crore
Yes.
in the valuation, and in our earlier order,
Yes, my lord.
it clarified that the valuation will be made by the petitioner
Correct, Milos, absolutely.
and made available to you.
Yes, my lord.
So on that basis, whatever would be the claim on you in respect of this transaction,
Yes, my lord.
as per the returns filed by you,
Yes, my lord.
or as per the notice served upon you by the tax authority, they would be entitled to pay that.
My only request is this. Now, we are governed by this report, right? my lord? This mediation report, what we sign. In this mediation report, what they say is, one, they undertake to pay me 3.15 crores. Sure. And that they'll also incur the burden of tax liability and will reimburse me whatever the tax liability is. So my restricted submission is only this. Whatever the tax liability for this transaction is there, which includes the 3.15 crores paid to me, whatever that is I don't want 1 rupee for myself. Whatever the tax liability, let them in the order disposing it off, please record that they will bear the tax liability.
Milos, can
That's
you
all I
Lordship
want.
clarify
I don't-
that this is
I-
not a
one
part
second,
of the.
Agarwal, 1 second. Very
No, I'm trying to assist saying
No,
that.
no,
Lordship-
I'm not finished. Just 1 second. Now, all I'm submitting is this. To answer your lordship for enrichment, I don't want 1 rupee more than what I'm entitled to. All I'm saying is I should not be worse off. I should not be saddled with the tax liability. If the tax liability comes, I will show it to him. This is the income tax. Please pay to the income tax directly.
Tax has to be your liability because that's what you
Yes,
are
Milos.
earning something.
Milos, it can't be income tax on share, I can understand, but he can't say now you pay tax on 3.15. This is for settlement of the matter.
Not asking that. We just said on the valuation,
Yes,
if there is a claim made,
yes, I'm undertaking, Milos. In income tax authorities will issue notice to me. I will say what is the valuation.
All lordship.
in the event of an liability coming,
Or may I have one suggestion, Lord, subject to what your lordships feel, my lord. Since this was entered into great difficulty with the mediator, let us go for the mediator once and resolve it once so that I won't bother your lordships. So the understanding, mediator knows what is the understanding. It is before the mediator, instead of me interpreting or my learned friend interpreting. Justice Shagdar knew on what context we had settled this matter. Please once refer it before the mediator. Let Justice Shagdar decide what is to be done.
Regardless of the settlement having been honored to the extent above, a dispute has arisen between the parties with respect to liability towards income tax on the sale consideration of the 3.15 crore
Yes.
paid by the petitioners to
And this is the tax
Conference fund.
order of the court. The settlement bifurcation.
In this regard, both sides are
Yes.
relying upon para 2 in bracket Roman 3 of the terms of settlement arrived at between them, between the parties. Terms of settlement dated 8th March 2025. So since the terms of settlement were were finalized by the law arbitrator, we request Rajiv Shabdar, former Chief Justice of the High Court, who was the sole mediator, who was the sole mediator, to hear the parties once again and resolve the above mentioned issue.
Yes.
Resolve the above mentioned issue. The parties are directed to contact Justice Rajiv Shabdar. The additional honorarium for the shall be paid by the parties in the mediator.
It was paid by them.
As
So there's two orders that lordships can pass today. One is to get the transfer forms and the proceedings can be quashed because 3.15 crores has been paid already. So there's only this question which will also anyway resolve it one way or the other.
Where is it?
You have the list of proceedings. Sir.
The following cases, the so-and-so FIRs are hereby, and all the proceedings arising therefrom are hereby quashed. So-and-so cases are also disposed of as having become.
Yes, Pillar.
Give the details.
I have the details are here.
My lord, slightly mundane, but I'm a retired person, so last time your lordship had recorded, the honorarium paid by the petitioners, it recorded in the order.
Now you've got some money.
No,
Now you've got some.
80-year-old man, lordship has recorded that.
You got from among them.
Grateful. मैं दे देता हूँ आपको.
And next item 42.
Yes, obliged.
Lord, this is that appeal by CBI against my bail order granted by the High Court. I put in 10 years already.
Well, we are being led by the learned solicitor. He's in some difficulty.
What happened in the High Court meanwhile?
It is still.
Lord, in the other matter, your lordships asked the High Court to hear it in 3 months. Those 3 months are expiring in the first week of May. The hearing has not started.
My lord, in this, the complainant, the last date of hearing.
First or second week of May.
No, that's not in this, but here, my lord, I should get bail, my lord. This is a different case, that's a different.
We know that, that's a different matter, but since that will have with regard to question of incarceration.
Yeah.
So that might have some bearing on the issue.
No, as far as that is concerned, my lord, nearly the sentence has been served.
In any case,
You know, their sentence is over.
The sentence is nearly served.
It's 10 years there. It's expiring next month. So that's gone. This is the one which is now not coming in my way.
But in fact,
what's the license?
Hold on.
This is the license.
No, what I'm saying is, Milan, there the sentence is 10 years. In the other one, that is now over. I have got bail here, which your lordships have suspended.
In that case, there are appeals also by the victim.
No problem. That's fine. That's all right, Milan. By and large, if 10 years is maintained, as part is then infructuous,
If the sentence is undergone, even
it is gone. Now here, by your lordships,
tomorrow we are in the 9 judge bench.
yes.
And that's likely to, though we will try to finish it in 2 weeks.
I know, I am aware, Milan. I am also appearing.
It will also be there definitely. So it will.
May I suggest, if your lordship may keep it, Milan, on the last Tuesday in April, after the CB is
First
open,
week of May.
or first week, or very well.
First
I have
week of
also-
May.
Because it has to be heard. He wants
First
to
week of
argue.
May.
My lord, I also have another thing to say, because what is happening there in the High Court is, in this particular matter, they have been taking adjournments. He moves an application and doesn't turn up, the complainant. So they can't be allowed to do this.
That you point out to the High Court.
No, the High Court is already seized of it. On the last date of hearing, the counsel was unavailable. Moves an application, my lord.
Whether
When the person is,
High Court or this court, we are not to be swayed by any.
no, I am on to one thing, my lord. Your lordship had sent us there with the purpose that the appeal should start. You move an application and then they don't appear. You seek an adjournment.
One day.
Hearing must commence.
The hearing cannot commence like this.
This order was passed more than 2 months.
Because I sought an adjournment for 1 day for personal difficulty. only 1 day. For personal difficulty, it could have been the next day.
Don't take dates.
That 1 day cost me more than a month.
No. I only sought adjournment for 1 day.
That 1 day that you sought cost me more than a month of an adjournment. It is very easy for you to say 1 day.
On the next date of hearing, don't take any.
No, I will not.
And
Plus,
you
I've
extend-
never
from
taken
your
any
side
date.
to extend full cooperation to the court.
Absolutely.
No, even the dates I can show, the number of dates he took during the appeal after I argued.
Things, cannot be an impediment in the way of the High Court to decide the main case, for which London General Counsel, stroke counsel for the party, has jointly stated that they will extend full cooperation to the High Court.
Grateful, Lord.
Item 43.
It's item 43, your lordships had directed the respondent to verify my medical reports, my lords. Well, we have verified, I appear for the state. The child is suffering.
All right, we can grant him, say, London State Council, say pursuant to the order dated 1st April 26, London State Council clearly states that the petitioner child is suffering from the disease mentioned in para 2 of that order and is critically ill. That being so, the condition imposed in the order dated 28th January 2026, prohibiting entry of the petitioner in the state of Chhattisgarh is suspended, and that condition is ordered to be kept in abeyance till further order. We just watch the conduct also and everything, then post the matter after 6 weeks or so. Or is kept in abeyance till further orders. However, the state shall be at liberty to apply for reinforcement of that condition if there is any change in the circumstances. Once a till further order is ordered to be kept in abeyance, and the petitioner is consequently, applicant petitioner permitted to stay with the child for the purpose of treatment, medical treatment. However, if there is any change in circumstances, state is granted liberty to seek reinforcement of the apostate. Item 44.
No, sir.
Suggest how they will repay
44.
My lords, I am appearing for.
This request, this may be taken next week.
For the respondent.
44 may be taken next week, or next Monday.
My lord,
Yeah, Lord,
even
I'd
I
ask
need
for
to
bail.
file my reply, my lord.
Let's show how you will pay that money, etc. Because large assets and liquid cash is attached by ED to the extent of 200 crores. I'm going to file an affidavit to show how it can be done, my lord. How it can be discharged.
You can file an affidavit.
I'll file that, Lord. I want it next
Lord,
month.
I will need 2 weeks to file my reply, my lord.
All right. Mr. Deputy Singh, in addition, also.
No, 2 weeks is too late.
And granted 2 weeks time to file the counter affidavit. Mr. Rudri also seeks 1
I'll
week
file an
time to-
affidavit to show, my lord, how money is.
1 week time to file it. In terms of para 2, order dated 26th February 2026, post the matter on so and so date.
Lordship.
Obligement.
Yeah, please, my lord.
Item 45.
45, my lords. These offences, if your lordships will see, are non-bailable offences, punishable with life imprisonment. Section 437 CRPC would operate as a bar to grant of bail.
No, madam, matter wise, it's not in matter.
My lords, may I request one thing? Make the trial time-bound, and he may submit his passport to the trial
Why we
court.
do not find any ground to interfere with the court of granting bail to risk number 1. However, we encourage the trial court to make an endeavor to conclude the trial proceeding, preferably within 1 year.
My lord, order for the passport to be deposited with the trial court as well. His passport may be deposited with the trial court so that.
Passport you can, the state and the petitioner shall be at liberty to move an application before the trial court, seeking addition of one more bail condition, namely the deposit of original passport with the court. The court will pass an appropriate order on that application after hearing the parties.
Lordship.
और तो क्यों वैसे भेजो कि
Lord, in item 68, it's an application for bail on medical grounds. He shifted from 100% blockade, my lord. He shifted from Ratnagiri.
Find out and meanwhile let him,
Lordship on Friday.
say the petitioner while in hospital shall be treated to be on interim bail, shall be treated to be on interim bail. Meanwhile, the state authority shall submit a status report regarding his health condition.
Lordship.
Listed after 4 weeks.
Great.
Thank you, Lord. I'm so obliged, Lord.
16, may it please. Because I appear for the petitioner in this matter, my lords. Fundamental error committed by the High Court, my lords. High Court agrees that under 74, tenancy could not have been granted. If that be so, the plaintiff could not have got the eviction. The High Court holds against me on that point. On that very point, the plaintiff had to lose. Please come to page.
I could say that you are not small kind of, these are all big companies and.
No, but at the end of the day, my lords, these are leases which are entered into the Land Reform Act.
Problem was, what you did was, you admitted that exhibit B3 is barred by 74.
Correct.
And you founded your case on the assignment to the partners by the partnership firm.
No.
At the time when the partnership firm was subsisting.
No, therefore, there are two aspects to
That's the
that.
problem, because that's
No, I
how
understand.
you have changed your stance before the High Court.
No.
In second appeal.
No, in fact, even in the written statement, we said so. With due respect, my lords, even in the written statement, we said so. The mistake, it was really not a change of stand.
When in possession.
We are in possession, my lords, for over several decades.
They never objected to our.
Yes, yeah.
They've admitted that it is come now.
And one more aspect, my lords, what fell from my lords, they plained.
They sued for renewal of the lease minutes for 30 years. That 30 years is getting over in March 27, even though they.
Proceedings are pending at their instance.
Ultimately, minutes, they got the benefit of the renewal effectively for 30 years. Because that is over in March 27. This can't go on forever, minutes. It's a property.
We'll see.
They were sold. 69 lease, 30 years. That is
Fixity of
getting
tenure
over
is there.
March 27. They got the benefit, minute, virtually. Now they can't say they will remain there forever.
No, fixity of tenure is the
Since you are already there, you file a very short affidavit, giving the status that who are they? Actually, the kind of corporate entities, how much land they are having and.
The corporate entity status is all gone. Because now the individual partners, on the basis of some right, they are saying that they will continue. So what the SQL partners wanted to do, they want to now claim fixity, which the High Court says they can't.
They recognize us as tenants.
Renewal. All the suits for renewal have been dismissed. But then benefit of the renewal, they have already secured. So my respectful submission is.
The only thing we have to examine is, admittedly, they are in possession.
Yes.
Whether the possession can be deemed to be that of a tenant or a person deriving rights from a tenant under section 6A.
Correct.
Or under section 13 of the Act.
Absolutely.
Right? So that
6A may not come because 6A is deemed tenancy, which will not apply when there is a specific tenancy. When there is a registered document, there can't be.
Kerala Land Reform.
Land Reform Act, my lords. 13 gives fixity of tenure.
Deemed may not apply.
And my lords,
deemed may
if
not
74 operates, then 6A and 13 will be attracted. Fixity of tenure will come.
The law is.
That's where the inherent contradiction of the High Court.
If you are holding under registered instrument of lease, once a lease is specific, there's no question of deemed tenancy. That is.
File in some detail, then we'll hear it.
Status quo, my lords, we are in possession.
Say so-and-so and consul are there, representing two so-and-so respondents, they may file the counter affidavit to tenant. Within 4 weeks, posting article for.
Give me a date, minutes of some kind. A posting date. A posting date, minutes I request.
That we are giving.
Yes.
Our possession has to, status quo has to be maintained.
Decree has to be put into execution.
Nothing has happened.
Nothing has happened.
You are free of cost everything and
No,
What your friend is saying, by litigating you have enjoyed what you.
But they, my lords, did that, my lords. They moved the suit. They moved the suit.
They made a big mistake.
They moved the suit, my lords.
I have
Therefore,
to sue for
my
eviction.
possession as of date should be protected.
I had to sue for eviction. What else can I do?
Son दे दिया है. वो एक lease
No, therefore, that possession has to be protected, my lords.
nobody has filed any against you.
No, but
execution has been put into execution. Decree is not put into execution.
they have not. But today, my lords, after this, they will be emboldened, my lords, to.
You are better off. Notice has been given by the Supreme Court. Another 30 years.
We'll see.
Very well. Very well.
Item 70.
70, my lords. I am for the respondent in 17. Oh, near kiya. Plus, I am for petitioner in 17. So he tells me to come this side.
Look at this. How do you justify an agreement of exclusionary clause
Exactly.
when no cause of action is falling within that jurisdiction?
No, that's what I'm saying. I am for the defendant. Neither I am registered nor he is registered. The plaintiff, your lordships will see three factors. Plaintiff is a Taiwanese
Cause of
company.
action of disclosure of confidential material takes place between defendant one, that is you,
And D2.
defendant two within the territorial jurisdiction.
Let's kindly see, what is argued is not that. Kindly see breach of agreement. Kindly see page.
Forget about what is argued.
Kindly see page 41. How
What
they
is
set up. Let's kindly see what is set up.
Page 92, point of jurisdiction, clearly pleaded.
Absolutely.
Let's kindly see page.
Clearly pleaded.
Let's kindly see page 41. Kindly see page.
Today they'll get a paper degree in United Kingdom.
It's not a question
You
of
will
paper.
enjoy all the benefits in Chennai.
Plus, with all due respect, if party autonomy is to mean something, clause
There's no
41.
party
Look,
autonomy.
would your lordships kindly see clause 70?
Jurisdiction clause.
Respondent to two and them.
Illusory jurisdiction clause.
It is not an illusory jurisdiction clause. In fact, your lordships have protected such clauses, Modi.
Correct.
Modi, would your lordships kindly see? Give me.
I could very clearly distinguishes that, saying that the defendant number two
Yes.
did not find place in those fact situations in Horlicks and other cases.
Minaj, it's not a question of kindly see Modi for a minute. Let's kindly see Modi for a minute. Your lordship's judgment, not the High Court judgment. Kindly see Modi. This part. Hand it over. Hand it over. Give. Para 11 Modi.
Clear tortious interference at the instance of D2
It is not.
and in Chennai.
Because
Particularly
kindly
in
see
Chennai.
para 11, kindly see para 11 of Modi. Your lordships were considering similar circumstances. Placitum FH at page para 11. Para 11, internal page 351. It is well settled. Your lordships have para 11 for a minute plus. It is well settled principle that by agreement the parties cannot confer jurisdiction where none exists on a court with which CPC applies. But this principle does not apply when the parties agree to submit to the exclusive or non-exclusive jurisdiction of a foreign court. Indeed, in such cases, the English courts do permit invoking their jurisdiction. Thus, it is clear that parties to a contract may agree to have disputes resolved by a foreign court termed as a neutral court or a court of choice created exclusive or non-exclusive jurisdiction. Now, kindly see my clause.
If the English, now this is.
Kindly see my clause for a minute.
This is how we will interpret Modi. If English courts permit their jurisdiction, even if there is an exclusive neutral jurisdiction in another court, your clause says that your contract will be governed by the English law.
Absolutely.
So we will apply that law and invoke our.
Question you have to apply. Plus, the Madras High Court
And
will
para
end up-
14, first sentence, what
The
is
Madras High Court, your lordships, kindly see the clause for a minute, plus 201. Because it's not just jurisdiction.
Law
And the
contract is English law.
Law of contract is English.
The
jurisdiction.
exclusive jurisdiction
Of the English court.
English court. Now, if law of contract is English jurisdiction, CPC will naturally not apply, and we will invoke, as you have relied on Modi, that the English courts would in certain cases
Correct.
invoke jurisdiction notwithstanding an
That will have to
exclusive
be tested
neutral
there. With
jurisdiction.
all due respect, that will have to be tested there.
Same principle.
Because today,
Same
today,
principle.
today, what
Para
your
14,
lordships
first
are-
sentence, what is falling from my lord's
Because
para.
my friend will hold his horses. Would your lordships kindly see? Today, what in effect the Madras High Court will have to do is two parties who are not situated in India the plaintiff and defendant number one, who is the primary signatories to the agreement. Neither of them are situated within India.
First,
Contract not
Civil
signed.
Procedure Code, plaintiff's jurisdiction is immaterial.
So defendants,
Territorial.
because the
It
defendant
is
also,
only the defendant's jurisdiction, one of them is in India.
because then
and
I
cause
am,
of action.
because at least,
Vital part of
because,
each.
kindly see this.
Plaintiff has no difficulty, plaintiff is already in India.
He's not in India.
Cancel.
Because plaintiff is not in India.
No, plaintiff is in India in the sense that they have already chosen to approach Indian court.
Because contrary to the agreement.
They have chosen to approach the Indian court.
Very well.
Number one, effective relief, ultimately they need to seek or they can be granted, is only against defendant number two, who is very well settled.
Because the primary prayers are against me. Kindly see. Because primary prayers are against me. Would your lordships kindly see primary prayer, page 41. Kindly see page 41 for a minute. In the application
As
seeking
far
leave.
as you are concerned, the only issue to be examined by the court is whether you you have transferred that technology or whatever it is to defendant number two.
Correct. The primary prayer is against me. Kindly see para 11, page 41, how they invoke it. Your lordship will just permit me to read it out. I state that the first respondent has acted in complete breach of the agreement and willful disregard. So it squarely arises out of the agreement.
No, unless this issue is going into the effective relief against number two can't be granted.
In which case the clause says even matters arising out of breach or ancillary matters, UK courts. Kindly see the clause. Put your lordship. It is exclusive jurisdiction, ancillary matters also, my lords. Kindly see the clause for a minute. I am saying.
Cause of action against defendant number two. Is there privity of contract between defendant number two and the plaintiff?
Because the primary causes, the primary relief is sought against me. If primary relief is for breach of contract.
Overlap, why won't the territorial?
Because in which case no exclusive contracts will be held good in India, Milos. In every case, they will break the jurisdiction. It is, because would your lordship kindly test it? Because I am.
Cases of jurisdiction is also not exclusivity, but a relevant consideration.
None of this considered. I can appreciate if your lordships test it. I am saying none of the judgments are considered. Your lordships will at least test it, because today what happens is two multinational corporations. Because two multinational corporations, I can understand. These are two exclusive entities working in two different countries. Because with all due respect, kindly see the clause. The clause says
Plaintiff and outside company is already here in India. They approach the court.
Because they
don't have any issue.
Because they have just
Defendant number two cannot run away because defendant number two is an Indian company, Indian entity.
We should encourage litigation friendliness in India.
That doesn't seem to be. Clearly this litigation friendliness doesn't seem to be, because then parties will be reluctant to transact business with Indian parties if Indian courts start. With all due respect, kindly see, it says irrevocably. The clause very categorically says irrevocably, including non-contractual claims. Because people who sign an agreement, some value should be attached to the contents of an agreement.
Right.
Because I am saying, would your lordships kindly see the impugned order? None of what falls.
These are all.
Because none of what your lordships are saying today doesn't fall from the judgment of the High Court. With all due respect, there is no application of private international law principles. Renwa not looked into. Nothing looked into, Milas, with all due respect. I'm saying, Milas, I get non-suited right at the beginning, because I am now before an forum which is not completely subscribed, neither by me, not by him. Would your lordship kindly see this? It's a matter which your lordship, in arbitration cases, your lordships would not have interfered.
Alive, and in due course of time, matter will come, we will examine it. As of now, let them proceed. Item 71.
At the outset, I'll draw your lordship's attention to the order in other matters. But can I just indicate one thing which distinguishes it? I'll just make the point to your lordship.
Don't make it, we will dismiss your order. You are worse of them.
You are named as principal.
You are the main player.
Mastermind. What use this principal mastermind?
Because charge sheet actually reverses it. Charge sheet says I was not.
You are getting bail. Then go ahead with your litigation.
What your lordship said at page 334.
Unfortunate lucky draw on that day.
Page 334, what your lordship said was you go and appear before the court concerned. Yes, that's why, I was just telling Justice, my Lord the Chief Justice, that what your lordship's order at 334, your lordship had said you go and appear and you will be granted bail, and you did raise all the objections at discharge stage.
That's so.
That page 334 is the order.
So, The SLP criminal number 1793 of 2026, filed by petitioners who accused already and dismissed on 4th February 2026. However, the petitioners who accused were granted bail. However, it was directed that in case the petitioners who accused, namely the petitioner in that case, however, with a view to enable the petitioners who accused, namely the petitioner that in that case to join the court proceedings, it was directed that their arrest shall remain stayed, subject to their surrendering before the trial court within 2 weeks and furnishing adequate bail bond through the satisfaction of the trial court. Next paragraph. Following the say, we see no ground to take a different view in this case. Consequently, the SLP specially petition is dismissed. However, with a view to enable the petitioner to join the trial court proceedings, his arrest is stayed, subject to the petitioner surrendering before the trial court within 2 weeks and furnishing bail bonds to satisfaction of the trial court, along with such other terms and conditions as the court may deem applicable.
I just want one more indulgence, Millards. Lordships, I'll make a discharge application, Millards, that the trial court may consider dehorse the observations in the impugned order. Millards.
Why you want the trial court to pass an order which will set aside in a minute?
Millards, what has happened is that the charge sheet is actually saying that I am not the beneficiary, Millards. And there is a civil suit filed for recovery. And there's a civil suit for recovery. Because that is their FIR allegations, but the charge sheet has said to the contrary. That's why. So that's why.
That's an independent right. Item 72.
Can I just also take indulgence in 1 minute? That other matter where Raghent and I were there, we just spoke outside to settle it. Unnecessarily going back to Mr. Justice Shakdar will be again an issue which will start. So I think Mr.
So as in Gaurav and me are the.
You have sorted out.
Yes, my lord. Lordship may, if subject to what your lordships feel, my lord, in the order, if your lordship says, whatever, like what fell from your lordships, whatever, any tax liability based on the valuation of the will be borne by them. That's all.
Give us the
Yes, we'll give the part. Yes, Lordships will give it.
Yes,
that, it's my work class already.
Instead of sending it to Justice Shakdar.
Yes. Then
Whatever is claim made to him, communicate, he will pay.
yes, and the quashing.
Give us a piece of paper.
We'll write it and give it. We'll sign it and give it.
Corporate executive.
We'll also write that 4 proceedings to be quashed, my lord.